by Mr. Kathman. We have Mr. View from the prosecutor's office and Officer Rose from probation. We're here today for sentencing. Has everybody had the opportunity to review the PSI?
Yes, Your Honor.
Any reason not to go forward with sentence today?
No, Your Honor.
No, Your Honor.
54 days of jail time credit and no restitution sound right to everybody?
Yes.
Yes, Your Honor.
Mr. View, on behalf of the state?
Just in terms of our recommendations, Your Honor, we are asking as part of the plea negotiations in the case, they did agree to a no contact order as to Helen O'Leary. Beyond that, I believe the recommendations of probation are appropriate.
Officer Rose, anything from probation?
No, Your Honor.
Mr. Kathman?
Your Honor, we discussed it in chambers and stand by that conversation. I plan to have a talk with Ms. O'Leary about if the court does deem it proper and correct to place her on probation, that I believe it would be a one and done if she didn't do what she was supposed to do, and that she needs to embrace whatever restrictions, conditions the court places upon her with a good attitude, or we might find ourselves back in here doing what I like to call well-dressed begging. Because if you violate probation, there's not a whole lot the attorney can do except smile and throw some mud on the wall. So we will have that conversation when this is over. The court places her on probation, and hopefully it'll go well.
Ms. O'Leary, what do you want to tell me?
I apologize for anything that I have done. I apologize for being here. And whatever you give me is what I'll do.
I don't know that, Ms. O'Leary, I apologize for anything that I have done. Is really, I don't know that helps us move the ball forward at all. You know, I think ultimately, Ms. O'Leary, this is going to be a punishment case. I have three kinds of cases that I have. I have rehabilitation cases, I have punishment cases, I have protect the public cases. And you're not a protect the public case. I don't need to protect the public from Ms. O'Leary. That's not a thing. I would like to think that you have some issues that you're not dealing with in your life. And I'm going to task Officer Rose with the primary purpose of helping you figure out what those issues are and addressing them. It might be drug and alcohol issues. I think they are. Might be behavioral issues. I also think that they are. And she's going to try to help you with that. If that doesn't work, this is just serve out your time, be punished for what you did. I am going to put you on probation for a period of 3 years. I'm going to credit you with the 54 days that you have already done. I'm not going to impose a fine, and I am going to impose the costs. I'm going to be subject to the standard rules of probation. I'm going to delegate to your officer the ability to make special or additional conditions as she sees fit. I don't want to load you up with a lot of things to do, Ms. O'Leary, other than I want you to get into treatment, and I want you to complete the Court's Thinking for a Change program. I want you to behave yourself. If you can do those things, then you and I aren't going to, and also no contact with the other Ms. O'Leary. If you can do all those things, you and I are never going to see each other again. And if you can't do those things, you and I are going to see each other one more time, where I sentence you to 180 days in jail and give you credit for whatever you've done. If you violate your probation in a big way and I have to send you to prison, then the maximum penalty also includes an optional period of post-release control of up to 2 years. So if you violate by committing a new felony or something that is a significant departure from your history, then I'm going to send you to prison for up to the maximum penalty, which is 36 months. Non-compliance, though, those kinds of things, that's going to earn you a local jail sentence and get on with your life. Anything else?
No, Your Honor. Thank you.
You have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer to obtain a transcript or to pay the cost, they'll all be provided to you without charge. Good luck to you, Ms. O'Leary.
Thank you.
Thank you, Your Honor.
I'll talk to you.
Sure. Take over.
You want a lawyer?
Sure.
Okay, I'm gonna enter a not guilty plea and I'll let you go talk to the prosecutor. I'll give you a lawyer. Do you work?
Yes,
Where at?
Down River Spring.
I'm sorry,
At Down River Spring,
how much do you make there?
like 40 a year, 40,000 a year. I just started working back up there.
Go out in the hallway. You're entitled to one at arraignment, and technically I arraigned you, so I should make you fill out a petition, but I won't, okay? So we'll give you a court-appointed lawyer. You go from there. Go out in the hall and we'll set you up. Thank you. People against. Forgash? Garrett William Forgash, 25T645-322A. Good morning again, Mr. Zimmer.
Selling that great group. Before you step forward, and give your name from the judge, speak slowly and loudly. Garrett Fordash.
All right, Mr. Zelnick, your client was in here on a super drunk charge, .187, and the prosecutor, you got the prosecutor to reduce this to impaired. Have you had a chance to review the report with your client, and are there any material additions, corrections, or deletions?
No additions, no corrections, no deletion.
Anything that you would like to say on his behalf?
One statement, it was a halcyon moment for him, brigadoon moment, because he has a great job. When he went there, he found that this could have impacted his ability to work for the school system because of the conviction there, and I believe he's worked that out with the unions. What's the one off?
All right.
That's all I have to say. I haven't got anything else to say.
Okay, you got to be careful. I mean, got cars, right? Ubers, Lyfts, 12 months probation. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. If you change your address, place of employment, or home telephone number, you do have to notify probation. And you have to report as directed to the probation department. No alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume any one of those. Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. I'm going to order that you attend. I had him go into AA. Did he provide you with proof of that?
Yeah.
You have proof of that?
Yeah, there's still, yeah.
Yes.
Mother's got it right there, Judge.
All right.
No, no, it's still here. So if he wants to look, they can look.
Just take a quick peek at them.
Just haven't seen an AA slip in a plastic bag.
Well, at least the dog can't eat it. Heard that story enough, or it blew out the window of the car.
Yeah, you're gonna have to make it a little better than this. You went to one of the Trent municipal, right? You have to try with it, but you've been trying to keep your job. I think it's been consumed by fear of loss and working with a supervisor.
Okay, so I'm just telling you, it was 14 days. You should have gone to 2. I'm not going to make a big issue out of it, but I expect you to go to at least one AA meeting per week until you're in outpatient treatment. I'm going to order outpatient treatment. Attend AA once a week until an outpatient treatment. Once you go to outpatient treatment, get in outpatient, you no longer have to attend AA or NA. I'm going to order the victim's impact panel as well. This is really a high breathalyzer or blood draw, okay? So 4 days jail, credit 1, serve 3, and I'm going to let you serve those. I'll let you serve 1 out by way of community service and 2-day court work program. So 2 days court work, 1 day community service. You can do that at any nonprofit organization. I'm going to give you until December the 20th to complete your 8 hours of community service. We'll set you up on the court work program. There's 2 days of that, $35 a day charge for that, for a total of $70. You're to submit to chemical testing, PBTs and ETGs. I'm going to say monthly or more on demand of probation. You understand that, sir?
Understood.
Okay, so fines $300, cost $225, 75 victims' rights fee $50, justice assessment $650, screening fee is $60 for 710, and you have probation fees of $240 for 950, court work program fees of $70 for 1,020, and $225 cost of recovery. So your total should be $1,000. $245. If you violate, your probation could be revoked. You could be incarcerated for 93 days. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. You do everything, no violations within the preceding 90 days, you're eligible by statute for early discharge after half the time, so you could make application then. Do you understand that? Do you have any questions?
Can you take care of that today? Fines and costs, all right, fines and costs paid today?
And then he'll meet with probation. Anything else?
No, I just want to make, and you rarely get this opportunity. Europe, Gary just said, it's the holidays. Everything they make is sweet as poppy seed in it. You understood what he said, right?
No poppy seeds.
No poppy, none of that cost, none of that, nothing, none of this.
All right.
Take the message down early, Judge.
Have a good day. Thank you very much. Good luck, sir. Don't come back and see me though, all right? Thornton, Robert Louis Thornton Jr., 25W837260. And I also have 25T644914B. Your name?
Robert Thornton Jr.
You're charged with failure to pay your fines and costs as ordered. You were supposed to pay those at the rate of $100 weekly beginning August the 4th of 25. We have a balance still owing according to probation as of the date of the show cause of $470. That's count one. Count two is that you failed to clear all your warrants by August the 25th of 25. Do you understand that?
Yes.
And you also have a no insurance charge. Does he owe, is that right, Lisa? Does he owe,
470.
how much, can you pull that up, Jennifer?
You have GIS up. Is that what I need?
Okay, that's all right. Can you tell me how much is owed on the no proof of insurance, Lisa, please?
260.
So you owe $260 on the other case. And that means you could get 26 days. If I find you could have paid and didn't, that is, it's your failure to pay was not without your fault. Do you understand that?
Yes.
And you understand all your rights on this advice of rights?
Yeah.
You read it?
Yeah.
Understood it?
Yeah.
If you plead guilty, you will be giving up all those rights, and we're not going to have a trial of any kind. Do you understand that?
Understood.
You have the right to an attorney. Be happy to provide you with one at public expense. If you would like one, would you like one?
Yes.
I know we're not guilty plea on these. Either way, you're going to come back in front of me, okay?
Yes.
All right.
Judge, that no insurance has a misdemeanor attached to it that's in warrant status. I'll pull it right now.
Okay. Just give me 1 second.
Yeah, you need conditions of bond. You need it?
No, I've got everything here.
Okay.
Yeah, I got,
Sorry,
I
you good?
didn't see the
Okay.
probation. All right, so I'm gonna enter a not guilty plea on both of these. I'm gonna give you a lawyer. And then you're going to come back in front of me either way, okay?
It's my commentary, my lawyer's here.
I'm sorry?
It's my commentary for what you were saying, like if I just didn't pay or just because I'm not paying, it's the time for me to speak with the lawyer.
No, we're gonna get you a lawyer first. And then I'm probably going to give him the other file too, or her. I don't know who's doing it. I don't think Ms. Patillo's here. So at any rate, we'll give you the other file too. We'll give him the other file or her the other file, whoever's handling this. And there's going to be another file because she just told me you have a warrant out for your arrest on something else. The companion citation on this no insurance. Okay? So you can go out in the hall. He'll set you up with a lawyer and we'll go from there. Any questions?
And now I have to wait till my lawyer here.
Pardon?
No, I'll have to wait till he goes.
Yeah, you go talk to the lawyer. We'll set you up. Thank you. He's pulling that out of the file, Jen. So we'll give that to the lawyer too. Saint Amor, Aaron Russell, Saint Amor, 25T646055. Your name, sir?
Aaron Russell Santamore.
You're charged with no license on a dog here. You have the right to a lawyer if you want one. I'll give you one. You want a lawyer? You're charged with having a dog that was unlicensed on October 14 of 25 at 12 p.m. on St. Paul near John R. and Trenton. That is a misdemeanor, punishable, 5 to 100 fines, 90 days jail. Costs are all those. Do you understand that?
I understand it's a misdemeanor. I don't understand the fines with it, the stuff.
Okay, but those are the maximum penalties. You understand that? You need to sign the advice of rights and read and understand the rights. If you plead guilty, you will be giving up all those rights and there will not be a hearing or a trial. Do you understand that? All right. So I'll send you to the prosecutor if you still wish to waive your right to a lawyer, and I'll let you converse with the Trenton City Attorney. Would you like to, you still wish to waive your right to a lawyer?
Yes, sir.
$100 personal bond. You don't have to post any money. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. You go talk to the prosecutor, and then you'll come back in front of me. What's the issue over here?
He doesn't want to talk to a lawyer now.
Okay.
Sorry about that. I have all my paperwork shown.
If you don't want a lawyer, that's fine. If you don't want a lawyer, that's fine. I'll recall your case momentarily, okay? As soon as they bring that other file, I'll call it again. You can go out in the hall. He's going to give this file to the prosecutor. Prosecutor will call you out.
Thank you, sir.
And then you can go see, and if he doesn't give you what you want, you can always ask for a lawyer later. Good luck. People against Robin, Lynn, Rogers, 25T646054. Your name, ma'am? You're charged with no license for an animal. That is a misdemeanor. You have the right to a lawyer. Do you want one?
Exactly.
Okay, we'll set you up with a lawyer. You can go out in the hallway. And either way, you're going to come back in front of me after you converse with your lawyer. You and your attorney will come in here, okay?
Yes, sir.
Good luck. People against Markham. Christopher. So,
Yeah, back. You just want this new one on Thornton.
okay, just wait. Just grab the Thornton files. Okay. And I'm going to call him back. And I'll keep this one here.
Here it is, sir.
Right there.
Oh, that's something. Okay. All right, Markham.
Yes.
Christopher Michael Markham, 25T6466968. B and C, your name?
Christopher Markham.
You're charged with not having a valid license on your person, improper plate, and defective equipment, and you have the right to a lawyer. Would you like one?
Can I get an appointed one?
Yeah, I'm gonna give you a court appointed if you want.
Yes, sir.
Okay, you can go out in the hallway, we'll set you up, all right? Good luck. Recalling Robert Lewis Thornton Jr., 25T644914, A and B. I now have the A file, and then also 25W837260. Your name?
Robert Lewis Thornton.
It's my understanding now, you told my court officer and you just indicate here you don't want a lawyer. Is that true?
Yes, because
I don't need to hear. If you want a lawyer, I'm going to give you one. If you don't, I'm going to okay. All right. Well, I already arraigned you on the two. You have failure to pay no insurance. You have failure to clear all warrants on the resist and obstruct. You also have this other file and failure to pay on that charge as well. And you also have another charge here of driving on a suspended license that I had to rearraign you in. Okay? Do we understand one another?
Yeah.
So I'm going to rearraign you on that charge. You're charged with driving on a suspended from February 11 of 25. They think you're operating a motor vehicle on King near Douglas and Trenton. That is a misdemeanor, punishable by up to 500 fines, 93 days jail, costs, or all those in 2 points. Do you understand that?
Yes, sir.
All right. You understand all your rights.
Yes, sir.
If you plead guilty, you're going to be giving up all these rights. We're not going to have a trial then. Do you understand that?
Yes, sir.
Okay. You want me to enter a not guilty plea for you?
Yes, sir.
So you're going to go to the prosecutor on one. I don't know what you're doing here.
If I.
Let's stop. Let me finish. You act like we're inviting you to a dinner party here, sir. You show up, you don't show up. This case been going on since March. February. No. You see all these red marks? See all those on there? Can you see that?
Yes, I know.
That means you're,
I see your red, but yeah, thank you.
that's warrants. That means you weren't here. It means you didn't show up when you were supposed to be. I don't know what kind of game you think you're playing here, but you better stop it.
Steve, you're saying that I'm playing games, but I admit it. But this is why I brought myself back in here to not have a lawyer. I don't think any of this is a game. I wouldn't be here if it wasn't. So
Don't give me this holier than thou stuff.
I don't.
You don't show up, you don't take care of what you're supposed to take care of.
Okay.
I'm sending you over the prosecutor. I'm entering a not guilty plea. You missed here, just so you know. Just so you know, you missed on March 6th, March 20, July 10, August 7th.
Stay in Providence. And at the
I'm sorry?
Stay in Providence.
I don't care if you stay in Tuscaloosa. What does that have to do with anything?
Responding to your question first.
Go talk to the prosecutor on, and that's going to Judge Hessen. These two are mine, and I will deal with the contempt charge on the no insurance and the probation violation on the resistant obstruct. So you go talk to the prosecutor on that one, if you still wish to waive your right to a lawyer on that. I'll send you to the prosecutor on that case. You can talk to him. And then you're going to come back in front of me on, if there's a resolution on that case, I'm going to send you to Judge Hessen. If there's not, then I'll do what I'm going to do, set a bond. And then on these two, we're going to go through these, talk about your violations of probation and your failure to pay on the civil infraction. Okay?
Yeah, I'm still lost between the fact that you're telling me why I didn't want a lawyer, and then you're saying that I just blew everything under the water. But when I try to elaborate more on the situation,
Sure.
you're just downing everything I'm saying without
Sure.
really the reason.
Sure.
And I don't.
This
I
is-
have a
you're
great
in a-
job. I have a career. I don't have a tedious job to where I'm jumping back and forth.
Sir.
And I have.
Sir, it's the fourth quarter. There's 2 minutes to go and you're down 41-3. I don't want to hear it. Go talk to the prosecutor. This case has been going on since February. Take your attitude out in the hallway. Norbert Pastors, 25T644584. Mr.
Mr. Zolnik's on that case, Judge.
Yeah. I don't know why they sent it in, unless he's got another. Miss Elisa, do you see Mr. Zelnick anywhere? Is Mr. Pastor here?
I don't see him in the hall.
Did you call him? He didn't, I don't know what happened on this.
Yeah, I'll give him a call.
Yeah, I need his client here too.
I thought his client was here, so maybe he stepped out, Judge. Because
Oh.
if I have it highlighted, that means I saw him in the council.
Okay. Well, he had that sentence. I don't know if,
Right, so maybe he's consulting with another client somewhere else and then.
um, Hey, Will, is Mr. Zelnick still in the building?
I believe he is.
Oh, okay. Can you do me a favor, please? Ask him to come in with his client, Norbert Pastor.
Well,
Okay, thanks. Jacob Christopher Lesnow, 24F242298.
Thank you for calling PM. Good morning, Judge.
Pam, I need Emily in here on Lesnow, okay? He's in front of me.
Sir, what was the name again?
Jacob Lesnow.
Lesnow. Thank you.
Thanks. Okay, your name, sir?
Jacob Christopher Lesnow.
This is file 24F242298. So let me just reiterate what's occurred. On October 9th, you were in front of me and you pled guilty to count 1, chemical testing, which is failure to submit on September 22nd. Then after a hearing, we had a hearing on count 2, and I found you guilty of failing to comply with the treatment recommendation of the guidance center. Then I told them to for you to submit the weekly testing. You're back here for sentence now. I'm getting the probation officer in here. You have the right to an attorney. You waived it before. You still have the right to a lawyer. Would you like a lawyer? Are you sure?
Yes, sir.
All right. Did you go and test?
Yes, sir.
Were you negative? How many times did they have you test?
Well, that would be, so it was a month now, so I either 4 or 5, and then I've been going to weekly treatment to the guidance center,
That's good.
and he just released it yesterday. So I'll let that taken care of, and I believe he emailed Ms. Casino as well. So he should have my release for the guidance center, and then I believe.
So you're treating how often at the guidance center?
Once a week,
All right.
weekly.
And you tested how many times since you were in here on October 9th?
5.
5?
Well, this is the 6th, correct? So be that week. Yeah, 5 because I tested this week too.
All right. Mr. Sino, good morning. Your name?
You know,
Has he tested negative like he's telling you?
so then the 6th, he tested October 14th, 22nd, and 30th, and he was all negative. And I did get an updated treatment report for him yesterday, and he attended all his sessions for the month of October.
Now listen, you want the good news or the bad news? The good news is you're compliant now. The bad news is you already got 5 technical violations now. Okay? That means you get another one. Actually, today I could send you to jail for 93 days. I'm not going to do that. But you got to start paying more attention here, okay?
Yes, sir.
Would you like to say anything else?
I remember our last time meeting here, you guys just were like, all right, we're gonna have a follow-up like a month later. That do not miss testing and keep going to treatment, do not miss that. And obviously, you know, it's not hard. So I did that. Finished testing, and even after this, I'm still gonna go with that. So test. I tested, I think, a couple Tuesday. So Tuesday, I tested this weekend. Like, I appreciate it. Like, you definitely could have gone a lot better.
So I've been too nice, but I haven't sentenced you yet.
No.
I'm not sending you to jail, but I'm telling you, I'm going to cut your breaks since you've been compliant since then. What do you think?
Well, I mean, at this point, he didn't finish the community service and court work program. He's actually set right out of it, and he would be completed November 22nd.
Yeah. So we got to extend probation then. Because he's not done with treatment, right?
No, it's not done.
Sorry.
Okay.
He said that he has to email you. He already has release forms.
All right. So listen, you've had too many violations. I'm not letting you off probation now. Okay. So I'm extending probation for 2 months until January 22, 26. I need you to complete treatment. You're going to pay additional costs of $75. You're going to serve 1 day on the court work program and pay $35 for that. And you're going to serve 4 hours of community service, which has to be due and completed by December the 20th. So you owe the court $35, you owe the court $110, and you have to complete 4 hours community service by December 20 and 1 day on the court work program, and you'll be on probation until January 22. So that's an extra $40, 20 a month in probation fees. So actually, you owe the court $150. Can you pay that today, or do you need time? If you need time, it's not a problem.
Yeah.
Pay by November 26th.
Okay.
Pay by November 26th. Okay, now listen to me. You seem like,
Would you want to keep his testing on me?
yes, and weekly testing will remain.
Okay.
Stay clean.
Yep.
Okay?
All right.
Weekly testing for duration of probation. Thank you for reminding me of that. All right. So anything else, sir?
No, I need it.
Good luck.
Thank you.
Here, John.
I'm on it.
John, 1 second. Yeah, it's over there, too. Okay, Robert Pastor. 25P. 644. 588.
For the defendant, I'm glad I paid back.
I just didn't know if you were gone, that's all.
No, I was.
The file came in and you weren't in here. Sir, your name?
Here's one. My name is Woodward.
Okay.
Judge,
We're just adjourning again?
yes, Your Honor, and
Thank
to fall on the sword. So I went to pick up Discovery. I got the order to them late. My mother was, as you know, was hospitalized and back and forth there and everything else. I was unable to pick it up. So
All right, we're gonna adjourn, no problem. We'll adjourn it for 2 weeks. Do we have the 20th, Lisa?
Yes, November 20th at 9:45.
Good enough?
yes, and Your Honor.
Or do you want earlier?
No, Judge, I just want to advise you that I'm prosecuting a jury trial with my daughter's first jury trial that day. If it goes, I might have to call and beg for any date.
Okay.
Thank you, Judge.
All right, and then, but you
Nothing
think,
if you
do
want.
you think, does this look like a case that's gonna resolve?
I think so.
Okay, well, if you have to, you have to. That's not a,
Thank you, Judge.
you're,
Oh, one last thing, Judge. His daughter is finishing a residency in New York for ceremony and family things are this weekend in New York. They have Richard Oda stay for his daughter,
sure,
medical.
that's great.
residency thing.
Great. Bonds continued $1,000 can leave state to go to New York. When is that?
We're leaving this Friday and coming back Sunday.
I'll just make it between 11, 7, and
9. Present before the court is Ms. Thompson, right?
Yes.
Represented by Ms. Chambers, and we have Mr. Harris from the prosecutor's office. We're here today for a pretrial, but it's my understanding that Ms. Thompson's going to be entering a plea of guilty to one count of assault. We're going to set this for sentencing. Is that accurately stated?
Yes, sir.
Yes, Your Honor.
Ms. Thompson, how old are you?
I just turned 40 on the 10th of October.
How far did you go in school?
10th grade.
Are you able to read and write English?
Yes.
Are you under the influence of drugs or alcohol?
No, sir.
Are you taking any medications?
Yes.
What are you taking?
I'm taking Trilithil for bipolar 1. Anxiety. I'm taking Visceral for anxiety and Remeron for sleep.
Are you taking anything that would interfere with your ability to understand what we're doing here today?
No, Your Honor.
Are you a United States citizen?
Yes.
We've had some discussions about your case. If you enter a plea of guilty to this charge, I'm not going to sentence you today because I don't know enough about you and I don't know enough about this case yet. What I'm going to do is conduct a level 2 pre-sentence investigation, also an evaluation to determine whether or not you're appropriate for a community-based corrections facility. We're going to come back here in about 6 weeks for sentencing. Has anybody made any threats, promises, or representations to get you to plead guilty to this against your will?
No, Your Honor.
I have a document entitled Change of Plea and Entry. It looks like on the second page is a signature above the line defendant. Is that your signature?
Yes, sir.
Did you review this with Ms. Chambers before you signed it?
Yes, I did.
Are you satisfied with the representation that you have received in the case?
Yes.
You're going to enter a plea of guilty to one count of assault. It's a 5th-degree felony, punishable by up to 12 months in prison and a $2,500 fine. There is no mandatory prison in the case, and there is a presumption that I would not send you to prison. If I do send you to prison, though, the maximum penalty also includes an optional period of post-release control of up to 2 years. Before we go any further, I want to make sure that you understand your rights. You're presumed to be innocent in this case. That means that you can't be sentenced or punished until you either plead guilty or the state of Ohio proves that you're guilty. If they can, You have to do that unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you at the trial, compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to this charge, you're going to waive all of those rights. You're going to admit that you did it. We're going to get on to the matter of the sentence. Is that what you want to do?
Yes, Your Honor.
Mr. Harris, what are the facts?
Your Honor, if this matter had proceeded to trial, the state would show beyond a reasonable doubt, in addition to all allegations in the indictment as to count one, that on or about July 28th of 2025, defendant Renetta Thompson struck corrections officer Leah Smith on 2 occasions at the Warren County Jail in Warren County, Ohio. This is while resisting commands.
Anything on those facts, Mr. Chambers?
Yeah, Your Honor.
Ms. Thompson, did you hear those facts?
Yes, I did.
Do you admit they are true?
Yes.
Do you understand the rights you're giving up by entering a plea?
I'm sorry?
Do you understand the rights that you're giving up by entering a plea?
Yes, sir.
Is this what you want to do?
Yes.
What's your plea?
Guilty.
Ms. Groko, can you give that to Mr. Aldridge? Based upon the plea of guilty, I'm going to find you guilty. I think that you've made a knowing, voluntary, and intelligent choice here today, only after you had been fully advised of your constitutional rights, which you waived and rejected here in open court. I'm not going to go into the matter of the sentence today. We're going to do a pre-sentence investigation, level 2, CBCF evaluation. See everybody back here in about 6 weeks. Anything else?
No, Your Honor. Thank you.
All right, that's all.
Okay.
Versus Jacqueline Jones, Washington.
Morning, Your Honor. Trevor Maybach with you. We're ready in that matter, Your Honor. Lauren Brown, Deputy Chief Public Defender, appearing on behalf of Ms. Jones, Washington, who should be appearing by Zoom.
Yes.
Ms. Jones, Washington, could you state your name for the record?
My name is Jacqueline Jones Washington.
All right. And you're requesting a forensic examination.
Yes, the court should have,
I have.
okay, yes. So, Your Honor,
Well, the findings on it.
yes.
Okay,
So
got it.
today is the date and time for a competency review hearing. We have, has the court received the finding?
I have a one dated October 16th of
That's the
25 that I've reviewed, finding her not competent to stand trial.
Defense has no further evidence to present.
Your Honor, the people would stipulate to the findings in the report dated 10/16/25 and have no additional evidence.
As I understand, they've indicated that she's not competent and is not restorable.
That is our understanding as well.
That's correct, Your Honor, and I intend to file an alley in the case for the court today.
All right, very good. The court will make the finding that the defendant is not competent, is not restorable, and will not attain competency within statutory periods. I will sign the necessary orders in this case that the court has been provided and will await the knowledge.
Thank you.
Thank you, Your Honor.
Thank you. Thank you, ma'am. Court does call the case People versus Ardeen Henderson.
Central Water Assistant Prosecuting Attorney People.
Your Honor, Alexis Kumai appearing with and on behalf of Ms. Henderson, who I believe is on Zoom.
Yes, she is, for the Wayne County Jail. Hello, Ms. Henderson. I don't know if somebody can unmute you. Are we trying?
We're trying, but I appreciate it.
Oh, you did it.
Hello, Judge. Hello, I'm here.
Okay. Can you state your name for me?
My name is Ardeen Beatrice Henderson.
Thank you.
You're welcome.
All right, what are we doing?
Your Honor, at this time, Ms. Henderson would like to request a preliminary exam. Discovery is complete to my knowledge.
All right. And what date are we? But I didn't know that we're going to do that. Ms. Henderson, how long do you anticipate being in the Wayne County Jail? Or do you have a release date?
Wayne County released me December 11th.
She has a sentencing date scheduled for the 13th of November in Wayne County. She also has an out-of-state hold.
All right. Well, I'm not gonna, could do the 25th, but unless there's an objection, I was gonna set it for December 2nd so that we could have time to arrange transport and the like. Is there any objection?
No objection.
to that? All right. Preliminary examination will be in person. I'll set that December 2nd, 2025, 9 a.m. That is before Judge Perry.
Can I wear some regular clothes?
Pardon?
Can I wear regular clothes to court?
That is going to be up to, you need to speak with your attorney regarding that.
Yes, Ms. Henderson, I'll see if there's anything we can do prior to your exam date to get you a change of clothes.
Thank you, because their uniform here doesn't fit me at all. Thank you.
Okay. All right. Bond will continue. Thank you, Ms. Anderson.
Okay, thank you.
Court calls the case, People versus Colin Vandervue.
Your Honor, Alexis Kumai appearing on behalf of Mr. Vandermeer, who I believe is also appearing via Zoom. Mr. Vandermeer, could you state your full name?
Colin Vandermeer.
Thank you. And Your Honor, our office is in receipt of the letter from the CFP. We would stipulate as to the finding and just request an adjourned probable cause conference date. I do have a green sheet and a finding in order.
All right. Any additional evidence from the people?
It was stipulated to that finding and ask the court to sign the order as prepared by defense counsel.
All right. Court, upon reviewing the report, would find that at this time the defendant is competent to stand trial. Would specifically indicate that the defendant can understand the nature and objects of the proceedings against him and can rationally assist in his defense. Therefore, the defendant is deemed competent, and I have signed your order. I will set a probable cause. You want a couple weeks out?
Yes, please.
Is what? We're coming up on those weird timing.
So 2 weeks.
The 20th. Probable cause conference will be set for November 20th, 2025, 9 a.m. Bond continue.
Thank you.
Thank you. Court calls the case, People versus Jeffrey Williams.
Ash Salts for the people.
Okay. This is Ron Brown.
Yeah.
Second room. I think it's going to be a waiver. Second room. It's going to be a waiver.
Okay. That's the public defender, Tanaka Carey, room, Your Honor, on behalf of Mr. Jeffrey Williams. I'm going to. Okay.
Okay. Oh, here it is.
Ron Brown Crane on behalf of Mr. Williams.
You all right? Yes, sir.
He's going to waive it.
Mr. Williams, you're going to waive your right to have a preliminary examination?
Yes, sir.
All right. You understand that that's a hearing where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right. Preliminary examination having been waived, defendants bound over to circuit court on both counts. Mr. Brown.
Ron Brown appearing on behalf of Mr. Williams, waive reading, standing, request adjourned, date, circuit court.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea as both counts. Pretrial will be set for
November 19th at 1:30 with Judge Conlon.
November 19th, 2025, 1:30, Judge Conlon.
Bond continue.
Bond in this matter will continue.
Thank
you.
I'll come to you.
Court does call the case of the People versus Randy Harper.
Ash Salts for the people.
Pardon?
He's coming here.
Good morning, Your Honor. Christopher Shemke, on my client who approaches. Yeah.
Morning. Your name, sir?
Morning, Your Honor. Randy Harper.
All right. What are we doing?
Your Honor, in the circumstance, I've had a dialogue with Madam Prosecutor. I'm going to ask for a brief 2-week adjournment so I could potentially solidify a plea arrangement.
Is he in residential treatment?
He actually just got out of residential treatment, Your Honor.
He did. Well, 20th or 25th? Well, the 25th or the 4th, I should say.
I'd ask for November 20th, Your Honor.
Probable cause conference, November 20th, 2025, 9 a.m. Bond.
Thank you, Judge.
Thank you, Your Honor.
Number 20th, thank you, Your Honor.
Yes. Court calls the case, People versus Robert. Is it Tepe?
Morning, Your Honor. Reagan Cook.
Do I pronounce that incorrectly?
Carolyn Foster Tucker on behalf of Robert Sakat. You said your name?
Robert C. Cotty.
Tepe? Yes. Okay, all right. All right, what are we doing
Your Honor, people have filed an acknowledgement in this case.
today?
Yes, Your Honor.
Good. Any objection?
No, Your
Case
Honor.
is dismissed. McNally, thank you, sir. Court does call the case, People versus Adam Atkins.
There's no water, assistant prosecutor, attorney for the people.
Ron Brown, appearing on behalf of Adam Atkins.
Take your hands out your pocket.
Oh, yeah.
Your name, sir?
Adam Atkins,
All right, what are we doing?
requesting an adjournment.
Do you have a green sheet?
I'll get it to you.
I'll need one.
I'll get it to you.
Probable cause conference without objection in this matter will be adjourned to December 4th, 2025, 9 a.m. Bond continued.
Thank you.
Court does call the case, People versus Security or Drains. Good morning.
Morning, Your Honor. Mike Gaddy, Assistant Public Defender on behalf of Mr. Drains on case 25F2 1045.
And Sherilyn Foster Tucker on behalf of Mr. Drains in case ending in 1685.
All right, in the case ending 1045, I have a nollie. Is that correct? Any objection?
No, Judge.
All right, that case is dismissed.
Thank you.
And what are we doing on the other matter?
We're requesting a preliminary exam.
All right, discovery is complete.
To my knowledge, yes.
And would the people have their witnesses available on the 18th?
Yes, sir.
Preliminary examination in person will be set November 18th, 2025, 9 a.m. That is before Judge Washington. Bond will continue.
Thank you.
Thank you.
Thank you.
Court does call the case of the People versus Omar. Is it Al Galazi? All right.
Trevor, people.
I think I put those letters in the wrong order. Sorry.
Yes, sir.
Sitting right there. No, we'll wait.
Good morning, Your Honor.
Good morning.
How are you? You need an interpreter?
English.
You can choose.
Really? What are we doing?
Your Honor, we're asking for an adjournment today. I apologize, I do not have the green sheet available. I just spoke with the prosecutor in this matter, and I think we are very close to a resolution. Do you need?
Your name, sir?
Omar Al-Ghazali.
And if we,
I beg your pardon, so this is our first PCC and we just have to fill out the paperwork and iron out final details. We'll be ready to go next time.
that's correct, Your Honor. And Your Honor, if we can, I'll get the information for an interpreter. My client will most likely need an interpreter. He's using a Google Translate.
What
app on his
language?
phone. What language is this? What language? Arabic, Your Honor?
Arabic, okay, all right. Then I will adjourn the probable cause conference to November 25th, 2025, 9 a.m. That's a Tuesday. So that you know, bonds will continue. Thank you. Thank you, sir. Court calls the case, People versus Cedric Green.
Trevor Maybell for the people.
Good morning, Your Honor. If it please this honorable court, Brandon Byrd on behalf of Cedric Green. Mr. Green, can you please state your... Yep.
What, were you hiding over there?
Not really.
Okay. But kinda.
Kinda, a little bit. But,
And you were, I just signed the appointment on this. You needed adjournment.
Please, Your Honor.
All right.
Thank you.
Probable cause conference in this matter will be adjourned November 20th, 2025, 9 a.m. Bond continue.
Appreciate it, Your Honor.
Thank you. Thank you, Mr. Green.
Thank you.
Court calls the case of the People versus Tiger Moore. Bless you.
Good morning, Your Honor. James Fatwelski, appearing on behalf of Tiger Moore, who is presently not at the courthouse. I have called him a couple of times and texted him. He is not present. I will say that he is homeless. He has been to every other court hearing. So I would ask the court to consider either adjourning the PCC for 1 week or setting a show cause so he can come in and explain what happened.
Must have been talking to Mr. Gaddy. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $10,000 cash surety. That warrant will issue immediately. Thank you. Court does call the case People versus Jerry Bigham.
Good morning, Your Honor. Good morning, Your Honor. Raymond Cook to the people. And good morning, Your Honor, and to your staff. May it please His most honorable court. Mohammed Nasser, P74485, appearing on behalf of Mr. Jerry Bingham, who appears standing to my right. Sir, state your full name for this honorable court.
Jerry Bigham Jr.
All right.
Judge, we are in the process of seeking a global resolution in this matter. There are a number of matters also before Judge Slay as well. In light of same, we're respectfully requesting one final continuance to the probable cause conference. I don't believe the prosecution has any objection to same.
That's correct, Your Honor, no objection.
If you're seeking a resolution, do you want something quick or you want me to put it out? I can do the 20th or
May we do the fourth, Judge?
not objection. Probable cause conference, December 4th, 2025, 9 a.m. Bond continued.
Thank you very much, Judge.
Thank you. Court calls the case People versus Amber Lee Almany.
Prosecuting attorney for the people.
Good morning, Anna.
You need to take your hand out of your pocket.
I was putting my phone in my glasses in there.
Just a second, really? Again?
I was right at the door.
Where?
It's gonna be a better day.
Girl.
It's gonna be a better day, Judge. Your Honor, Assistant Public Defender, Tanaji Carey Akinruli, on behalf of Ms. Almany, we are asking for.
Can you state your name, please?
Amber Almany.
Thank you.
Judge, there is a resolution. The people have asked that Ms. Almany take a class. So we want an adjournment to allow her to get that class and see if it can help with our negotiations.
Okay, and how long will she need to get that done?
I'm gonna help her find it. It's a gun safety course, Your Honor. I think it's a one-day class that she can take. So 2 weeks is fine with us, Your Honor.
She's gonna be able to get into a gun safety class in 2 weeks? No, she might. I don't know what they're gonna teach her, but anyway.
Whatever.
Why don't I do this? December 4th.
That is fine, Judge. Thank you.
2025, 9 a.m. Apparently you've never taken one of those. Miss
I
Eckert,
have
right?
not.
No, I can tell. All right. So, I'll do that. All right. Then you, of course,
All right.
have no green sheets this morning, apparently.
You know what, Judge, somebody drafted them for me. They're not in here, so I'm gonna get them.
Oh, you're going to throw somebody under the bus? Because
I
they,
just said
no,
somebody.
it's somebody else's responsibility. I'll await them, and then when I get them, I'll sign off on all of them, apparently. Thank you, ma'am. Bond
Thank you.
continued.
Thank you so much, Your Honor.
Court calls the case, People versus Bryant Neal.
Ready, Your Honor.
Prosecuting attorney. James Fifelski, attorney of record for Mr. Neal.
And good morning once again, Your Honor, and to your staff. May it please the most honorable court, Mohammed Nasser, P74485, also appearing on behalf of Mr. Neal. Sir, please state your name for the record.
Bryant Michael Neal.
Judge, may it please the court?
Yeah, you're on this how?
We got retained. We filed our appearance. However, a substitution didn't make it to the file. I did speak to your fine clerk as well. So in speaking to brother counsel, he has no objection. I will file a substitution of counsel.
Yes,
we'll do that.
We would need that.
Yes, Judge. And we're requesting a continuance of the PCC. I've spoken to the prosecutor. Discovery is voluminous. I know that Mr. Neal does have a copy of the discovery. Be that as it may, I needed to review. So may we have the same date, Judge, of the 4th?
Any objection from the people?
No.
Probable cause conference, December 4th, 2025, 9 a.m. Bond continued.
We'll be here, Judge. Thank you.
Thank you, Your Honor.
Thank you.
Court calls the case, People versus Cortez Fairley.
Morning, Your Honor.
Morning, well, Jake Columbia.
Sorry to wake you. No, go ahead.
Actually, I'm pretty much dozing off. Mr. Fairley? Judge, I was just appointed yesterday, so I'm not real familiar with Mr. Fairley. Is Mr. Fairley audience? Judge, I'm sure he's here, but he just doesn't want to respond. So
Is that right?
I would like to ask for a 2-week adjournment.
You would. Well, you've asked and denied.
You being a considerate judge,
Yes.
you are.
Bench warrant will issue for defendant failure to appear. Bond will be set
Would you consider a show cause?
considerably in the amount of 10,000 cash shares. Excuse me?
No show cause?
You know what? Daddy, where's Daddy? He is? He may stay there. People keep asking. We'll issue immediately. Thank you.
Thank you for your consideration.
Court does call the case of the People versus Devontae Gambles.
Overwater Assistant Prosecutor.
Good morning, Your Honor. May it please the Honorable Court, David Burgess on behalf of Devontae Gambles.
Wendy Barnwell, P42505, withdrawing, file a motion to withdraw. I still Mr. Gambles.
Got it. Okay. I will permit that withdrawal, given the circumstance. Go ahead, Counsel.
Your Honor, I've just been appointed to the case. I'm just asking for a week adjournment, Your Honor, to just get caught up. So I think there's a green sheet in there, Judge.
There is, unlike Ms. Akinrulli. Probable cause conference will be adjourned to the 13th. November 13th, 2025, 9 a.m.
Thank you, Your Honor.
Your name, sir? Devontae Gambles. Thank you. All right, thank you. Bond continued. All right. Court calls case People versus Dwight Miller.
Yeah, Mr. Miller, it's my understanding Mr. Miller is, Mr. Miller, I don't know what you're showing us, but what, would you state your name for the record?
American State National. All my rights have been violated. They can't.
Did you state your name first?
American State National, man. Your Honor, I've been asking for the whole time, man. There ain't no firearm. There never was a firearm. I was kidnapped. My rights was violated. The lady lied on the scene. She said she called the police, said somebody pointed a firearm at her. Then when the police came on the scene,
Sir?
she made that
Sir?
statement again, and then it was proven, the
Sir?
cameras proved none of that happened.
Sir, if you want to try to overtalk me, you can. It's not going to work.
Dwight,
It's not the time for you to try to litigate your case.
Where's the
Dwight,
firearm?
Dwight, just listen. I was just appointed yesterday. Mr. Gaddy gave me the discovery this morning. Why don't we ask for a 2-week adjournment and you and I can talk?
Where's the firearm? Where's the so-called person that's the victim that signed the sworn
Any
affidavit?
objection from the people?
No, Your Honor.
Probable cause conference will be adjourned
I object.
to
I object. I
November
object.
20th.
I object. I object. I don't get
Objections
consent.
noted and denied.
You violate my
November 20th,
constitutional rights.
2025,
I
9
ain't about to
a.m.
write you up.
Bond,
I'm about to send
bond
up a
will
judicial
continue.
review.
And you know what? So
I'm about
let's
to
do
send
it this
judicial
way.
review.
That hearing will be in person. So if you got
my
something to
back
say, you
messed
can
up.
come right here and say in
My
person.
back messed
Thank
up.
you.
You know that.
Mute him.
You know my back messed up.
You're welcome. Court does call the case of the people versus Jawante McFarland.
Good morning, Rob J. Cole on behalf of Mr. Farland. Judge, may we approach?
You are just having a bad day, aren't you? You are.
It's going to get worse. It's going to get worse, Judge Slay. Can we approach very briefly?
Mr. McFarland, can you state your name, please, sir?
Yes, sir, Jonathan McFarland.
Thank you. Yes, you may approach.
Okay. Mr. McFarland, I've asked, you're doing really well with the lady that's seeing you. I'm asking the judge to adjourn this another 30 days so you and I can discuss it further, okay?
Okay.
All right. So probable cause conference without objection will be adjourned December 11th, 2025, 9 a.m. Bond.
Thank you, Your Honor.
Thank you. Court calls the case, people versus Marcus Jackson.
David I. Goldstein appearing on behalf of the defendant. Mr. Jackson, please state your name.
Other side.
Oops, sorry.
Your name, sir?
Marcus Jackson.
Thank you. What are we doing?
Your Honor, there's going to be a waiver. As soon as Mr. Jackson signs the form, I'll give it to the court officer.
You're waiving your right to have a preliminary examination? All right, you understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it. You understand you'll not have that here. You'll proceed to circuit court for further resolution. People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over on the single count. Mr. Goss.
Your Honor, we acknowledge receipt of a copy of the information. My client waives its further reading, stands mute, asking the not guilty plea be entered.
Defendant every way form of reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
November 19th at 1:30 with Judge Collins.
November 19th, 2025, 1:30, Judge Conlon. Bond will continue.
Thank you.
Thank you. Court does call the case, people versus Antonio Boswell.
And good morning, Your Honor. For the record, Terry Johnson, P70773, on behalf of Mr. Antonio Boswell, who was present and stands to my right.
Sir, can you state your name?
Antonio Boswell.
Thank you. All right.
Oh, want to approach?
We can. Your Honor, may we approach?
He looks shady. Yeah, I know. All right, yeah.
It's I'm a Spartan. He doesn't,
What?
I know I'm in enemy territory. I'm a Spartan, so you gotta.
You just don't know how bad the territory is. Just because I'm not a Wolverine.
Oh, I know.
Yeah, you should.
I know.
Okay. This may take a while because I'm Spartan, so he has to talk. We have to talk slow. Come on.
Good morning, Your Honor. David Knight.
Judge, in this matter, we'd like to set an exam.
Discovery is complete.
Yes, Your Honor.
People have their witnesses available the 8th.
Judge, I have a trial with Judge Kuhnke starting the 17th. Is it possible we can move this out? Or
I can set it the 18th. I can set it the 25th.
I know, but I can't be here on the 17th. I'll have somebody cover for me. Wait, let's do it the 17th, Judge.
The 18th, you mean?
I'm sorry, the 18th, yes. And may I address bond when appropriate?
Yes, you may. Let me set preliminary examination in this matter will be set for November 18th, 2025, 9 a.m. That is before Judge.
Judge Washington.
I don't think so.
Judge Washington.
That's before Judge Washington. All right. Chance to bond.
Judge, it's my understanding that my client is self-employed. He's a contractor. He unloads semis. He promises to appear for all future court hearings. He would ask that if the court does release him, if it has to be, he agrees to a tether. He's in neglect court regarding his daughter. He would like to attend those hearings in person, and he's not a flight risk. Again, he would agree to a tether. And he's posted bond on his other matter. So he's asking if the court would allow a PR bond in this matter.
Response.
I would object to any reduction in bond. In this case, he was present with the victim and their child, and the victim because he went through her phone and knew she was cheating on him. He then put his hand around her neck and strangled her, broke her phone, and was trying to prevent the victim from leaving the room with her child, for their child. I would object to any reduction in bond this time.
Was he on bond at the time of?
No, he
Other
had
matters
posted
at the time of
bond. I believe he had posted bond, right?
Yes, sir.
Well, right, but
I'm sorry,
but
yes.
he's on bond. He had just posted when this allegedly occurred. Is that right?
Yes, Your Honor. He disputes what the prosecutors, what they're stating. But yes.
Understood, but he'll have a preliminary examination to have that looked at. Motion for bond reduction, given those circumstances, is denied. Bond will continue. Thank you.
Thank you, Your Honor.
Thank you, John. Thank you, sir. Court does call the case, People versus Thomas Gay.
Your Honor, we have a vote of people.
Good morning, Your Honor. Christina Saxon for Thomas Gay, who's on my right. Mr. Gay, please state your name for the court.
Thomas Gay.
You're requesting an adjournment.
Yes, Your Honor. I understand that there's a possible resolution. The prosecutor and I have spoken and possibly even resolve this before the next hearing.
Probable cause conference will then be adjourned to November 25th, 2025, 9 a.m. That's a Tuesday. Bond will continue.
Thank you.
Court calls case People versus Alicia Allen.
That's justice for the people.
Good morning, Your Honor.
Assistant Public Defender Brian Bowling on behalf of Miss Allen. Can you state your name for the record?
I'm Lisa Allen.
Your Honor, we're asking that this matter be set for an exam. All discovery is complete to my knowledge.
And would the people have their witnesses available the 18th?
We can try to take it.
Preliminary examination in person will be set for November 18th, 2025. 9 AM, that is before Judge Moore.
Thank you, Your Honor.
Thank you. Bond continue.
Your Honor, may I address one issue of bond?
You may.
It's my understanding that the last time Miss Allen was before you, denied the request for her to be released to treatment. If it became available, I'd just ask you to reconsider that.
And Your Honor, I'm sure the court recalls when we were here before, I let the court know about my concerns, any change in her treatment, any change in her bond rather, at least the treatment, which is extremely unusual, but given the fact that this case, if she was driving down 94, hitting more, I believe she hit at least one car, if not two cars, and this is an OWI third offense with a child as well in the vehicle. So I'm very concerned about her getting out of all this time.
And has treatment been arranged at all, or?
I don't believe so, Judge. There are other holds that she need to address as well. Just if it became available, we'd like to have her be able to have that opportunity to go into that program.
I mean, certainly if there were treatment available, I'm not going to have a problem. I mean, I have some issues. It's more the manner in which, I don't have a problem with the treatment. I have a problem with the manner in which she's released, making sure that we have enough safeguards and controls regarding her release.
Okay.
So at this time, what I'll do is I'll again deny the request. But if you come up with something, certainly get it to the court and I'll be happy to take a look at it.
Will do. Thank you.
All right. Thank you.
Thank you, Your Honor.
Thank you. Court calls the case People versus Larry Atkins. Or Larry. It's Larry. That's right. It's Larry. It's Larry that people messed up. I'm looking at it, I said, I know it's supposed to be. Man, I'm sorry. Go ahead.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Atkins. Will you say your name for the record?
Larry Atkins. Yes, I know. Okay.
Your Honor, we did finalize a mitigation report that's been provided to the people. They just need an opportunity to review that. Could have an adjournment.
Probable cause conference will be adjourned until November 25th, 2025, 9 AM. That is a Tuesday.
Tuesday.
Bond will continue. Thank you.
Yeah. Okay.
Court does call the case People versus Robert Burnett. Three cases.
Assistant Public Defender Sandra White on behalf of Robert Barnett.
Your name, sir? Robert Burnett.
And Your Honor, we were here before and we have identified that two of these cases are duplicates, so it's going to be only filed. I'll have the case number for you here in just a moment. I apologize for the delay. But other than that, I think we are really looking at an adjournment for today's matters.
That is correct, Your Honor. We are asking for an adjournment on one of the cases, 25 F5 5793. We are still looking for media on that case.
On 5793.
Yes, we're still asking for body cams or any available videos.
Okay.
And the other one, I have two case numbers because I'm not sure which one is going to be dismissed.
I am.
Right. No, I got you. So, but you're ultimately looking for an adjournment on both of the ones that remain.
That's correct, Your Honor. And if I may address bond.
Hang on one moment. Let me make sure my paperwork is right. So probable cause conference in this case will be adjourned to the 20th. November 20th, 2025 at 9 AM. Bond will, well, yes, I'll address bond in a moment. I just want to get one that's going to be dismissed all set. Is it gonna really matter?
Ultimately, I think it's going to be the. Oh my gosh, hold on. I think it will end up being the 24FB1406.
That will be dismissed?
Yes.
Okay.
But I believe that one, it will be out of paper, but I do think it will be that case.
The 1406?
Yes.
Okay. And I'm assuming there's no objection to the dismissal?
No, Your Honor.
Right, so
No objection.
I'll mark that one as is. If there's some reason that's not it, then we'll deal with that. All right. And then the other case, I will adjourn to that same date of November 20th.
Thank you, Your Honor.
And then Esteban.
Yes, Your Honor, I do believe it was addressed at the last hearing, but Mr. Barnett wants this court to know that he will abide by all bond conditions. I believe one case is over a year old, and he was an addict at that time. He is currently doing Dawn Farms. He's doing it very successfully. He wishes to continue his treatment outside. If he cannot have a PR bond or home confinement tether, he wants to be released for treatment.
And I do think he was in bench warrant status at the time of the 2025 case.
Yes, he was.
That's my objection at the last time here.
And that is my same objection. And he was in bench warrant status for a period in time. So I'm going to, again, deny the request for a bond modification in this matter. Bond will continue. Thank you.
Will Your Honor consider release to treatment?
Pardon?
Will Your Honor consider release to treatment?
Certainly, I typically don't have an objection to somebody being released to treatment. So the only thing that you have to make sure, I would like a tether on that upon his release because of his failure to appear. And also that if he fails to complete the treatment, that he's returned immediately to the jail.
Absolutely.
All right.
Thank you.
Thank you. Court calls case People versus Emily Bates.
And Thornwater, Assistant Prosecuting Attorney for the People.
Good morning, Your Honor. Kim Adadish on behalf of Ms. Bates, who is on Zoom. Ms. Bates, can you unmute and state your name for the record?
Good morning, Your Honor. My name is Emily Bates.
Good morning.
Your Honor, we are asking for, I know I said one last adjournment last time.
You did.
We are
Wrote
incredibly.
it down.
Yes.
And I knew you were not truthful.
But the prosecution have offered something even better. So we're just hoping to adjourn a
So
month.
you're blaming it on that?
No, I'm blaming myself completely.
It is my fault.
Always my fault.
Oh,
I'll take it.
taking the hit for you.
You get to choose.
How much more time did you need?
4 weeks would be great, Your Honor.
4 weeks?
Yes. Or 3 weeks. 4.
So I always thought, I'm like, I know I go down, like.
December 4th,
But
2025, 9 a.m.
Thank you.
Okay.
Thank you, Your Honor.
Thank you, ma'am. Take care. Bond continued. Court calls the case People versus Eduardo Benavides.
That's yourself for the people.
Really, Your Honor, on behalf of Mr. Benavides. Mr. Benavides, state your name for the record.
Thank you. Really? I can really?
Your Honor.
What?
We are.
It's okay. Sometimes there's days that way.
I got this privacy screen on my computer. It's hard to see. I got to tilt it the right way. We're asking for an adjournment, Your Honor. We do not have a resolution yet for Mr. Benavides, but we're hopeful that we could get one. He does want us to address bond judge.
November 20th, 2025, 9 a.m. Without objection. Yes, Esteban.
And Your Honor, we're asking that Mr. Benavides be given the opportunity to have a PR bond. I do know that there was an issue. He did miss his court dates. The court
He did.
Yep, the court was kind enough to recall the bench warrant, but there was a bond issue relating to testing. I believe there were missed tests.
Yeah.
There were 2 missed tests, and then obviously coupled.
That was after I had canceled his warrant. He then didn't test. Right?
I think that is right, Your Honor. I think I might have,
No, you had it right. I just want to make it very clear for the record.
yeah, got it. So Judge, Mr. Benavidez reports that he is currently employed. He had been working for the past 90 days before he lost his bond and was subsequently arrested. He reports that he has stable housing. He has family whom he lives with. He does now understand, Judge, the importance of not only coming to court. He has been very active with us in regards to his court dates. He lives in Clinton, Michigan, so he's not very, very local. So it is a bit of a distance. And I can't say that testing was not being done because he could not make it to community corrections, but I know he was having vehicle issues, which is what made him miss court. He knows now, Your Honor, that it's extremely important that he tests as directed by the court, as well as make sure that he communicates with us with any delays in regard to his upcoming hearing.
I don't need a response. Motion for bond reductions tonight. Under the circumstances, bond will continue.
Okay.
Thank you.
Thank you.
Court does call the case. People versus Winona Harvey.
Overwatch Assistant Prosecuting Attorney to the people.
Michael Gaddy, Assistant Public Defender on behalf of Ms. Harvey.
Harvey, can somebody unmute? Can you state your name for me?
Yeah.
Winona Harvey. Thank you.
Yeah.
All right, what are we doing?
Your Honor, this is an adjourned competency hearing. I have had a chance to review the competency report. My office has gone over the report with Ms. Harvey. We do not object to the report.
She is still incompetent, is that correct? But likely to, if she's provided treatment.
That is
she currently in her course of treatment regarding that, or?
That I don't know, Your Honor. The report was not clear that I saw.
My impression, Your Honor, was that she's not. She's still
active.
Oh, she is still here. Yes.
She has not been. I don't think she's been found incompetent yet. I think that's what we need to do.
Yes, that's.
I thought this was a review. Hold on a second. I got the wrong one. Okay. All right. Any other additional information for the court?
None, Your Honor.
Your Honor, the people are received the report as well and have reviewed it. We have no objection to the court relying on context regarding to competency.
At this time, the court would find that the defendant is this current time incompetent to stand trial, but likely to obtain competence within the statutory period. And so when presented with the order, I will sign that, Mr. Gaddy. I will set a review competency hearing for, give me, she's not out of there yet, so give me 90. We'll move it up if necessary.
Judge.
Set a review competency date for February 5th, 2026, 9 a.m. Yes, ma'am.
May I know today's day?
I'm sorry?
May I know what month this is? May I know what's going on? Can I know what's going on? May I know what's going on? Can I know what's going on?
All right, you come back to see me in February.
What month is this?
November.
Can I say, okay, all right.
That's what I'm gonna order. And your
Can I get
bond
some
will
paper?
continue.
Can I get a
We'll
paper?
see
Please?
it.
Can I get a paper
Pardon?
from the front that's saying when I go to court?
Yeah, your attorney will give you one.
I'll send you a
Where's
notice, Miss Harvey.
No, I don't want to notice.
Okay, you won't miss it, trust me. All right, thank you.
The court with an order. Thank you.
Yes. Court does call the case. People versus Anthony Campbell.
Special calls for the people.
Morning, Your Honor. Michael Gaddy, Assistant Public Defender for Mr. Campbell, who is here to my right. Your Honor, we're seeking a brief adjournment. Mr. Campbell has an assessment scheduled with the 15th District Sobriety Court that may be informative of this matter as well. That assessment is scheduled, I believe.
Does he have a medical marijuana card?
You have a medical marijuana card?
No.
He does not, Judge.
Mr. Allen.
Is there a bond violation report? May I approach?
Progress report, yes.
Your Honor, thank you for letting me look at the bond form. Mr. Campbell is I believe he has a medical card that is expired. He reports he does have an appointment this afternoon.
He's also here on 2 charges of OWI with occupants under 16. So he really shouldn't be using any substance. But
yes, Your Honor, I'd ask the court to give him an opportunity to continue testing, to abstain from marijuana, and allow the court to watch these numbers to the extent that they are positive, continue to drift downwards until they hit 0, which may take a brief amount of I think sometimes up to a month to actually zero out if someone has in fact been using. But I'd ask him to allow him to continue to test and address that.
Probable cause conference will be adjourned to November 20th, 2025, 9 a.m. This time, given the defendant's violations, his bond is revoked. No, my bail. Thank you.
Thank you. Your Honor, I didn't catch the adjourned date.
The 20th.
Thank you.
Court calls the case, People versus Nicholas Chalmers.
Trevor May, welcome to people.
Brian Bowling on behalf of Mr. Chalmers, just approaching, Your Honor. Amen. State your name for the record, please.
Nicholas Chalmers.
Thank you.
Your Honor, I'm asking for an adjournment in this matter. Mr. Mayville and I are working to get a video issue ironed out, which I think we've resolved.
You think
we just need to get it over to my office.
Got it.
And then I'd like to address bond if I may.
Probable cause conference will be adjourned to November 20th, 2025, 9 a.m. Yes, as to bond.
Your Honor, my understanding, the current bond in this matter is a $10,000 bond that was set when Mr. Chalmers missed court back in early October. He's been in custody for 9 days since surrendering himself on that bench warrant. He does reside in Ypsilanti with his grandmother. His mother's here in the courtroom today to provide support to him. He does have a 5-year-old son, and he does work at FedEx. He's hoping that job will still be waiting for him when he leaves custody, whenever that is, hopefully today. I'd ask you to consider reinstating the personal bond that was originally set in this matter. If no objection to a tether, if you feel that that is appropriate.
Why did he miss this court date?
I got the days messed up. I'm sorry, Your Honor.
That sounds like a FedEx issue. You got the days messed up.
Yeah.
And he came back into custody because he turned himself in.
He did turn himself back in, Your Honor, to his credit. And like I said, he's been in custody for 9 days since then. I'd ask the court to give him another chance. This is the 4th PCC. To my knowledge, he had appeared for all prior ones prior to the one in October. And he's here today.
Yes, he is. Thank you, Mr. Bowman.
You're welcome, Judge.
Response on the people.
Under the circumstances, I'm not objecting, Your Honor. The defendant has a very limited criminal history. However, what is on there, though petty, is from out of county and shows failure to appears on both of those files as well in its past. So I just wanted to make a note that eventually the courts are going to start taking note of that, but no objection.
All right. I'll reinstate his previous bond, but he cannot be released without a GPS locating.
Wonderful.
Tracking.
Thank you very much.
You understand that, sir?
Yes, I do, Your Honor.
I'm just gonna tell you this. I'm doing this and I dare you not to show back up. Understood?
Understood.
All right. You do that.
Thank you.
Thank you.
Thanks, Judge.
Yes. Court calls case People versus Shane Campbell.
Prosecuting attorney to the people.
Cameron Radish on behalf of Mr. Campbell, who is on Zoom. Mr. Campbell, can you please state your name for the record?
Shane Campbell.
Thank you, sir.
Your Honor, we are going to be requesting a short adjournment to continue plea negotiations. There also is a potential conflict, so we're going to be
There's what?
potential conflict.
We don't know yet,
It was very recently.
but that all goes through Mr. Brown. Did you ask him?
It's all, it's on me. It's not on Mr. Brown.
You're just trying to take the hit.
Yeah.
Not working.
It was very recently discovered, Your Honor. I believe this is Mr. Campbell's first PCC.
Okay. I want to blame Lauren for something, but everybody's covering it. Probable cause conference, I'll adjourn it to November 25th, 2025, 9 a.m. Hopefully they'll have everything worked out. Okay, Mr. Campbell, that's a Tuesday. All right, sir.
I have a different court date on the 25th.
Where?
Dearborn Heights or Dearborn.
Like them better than me?
No.
No. I don't answer. Don't answer that. All right, what I'll do then, after that, we go through the holiday. I'll make it December 4th,
Thank you, Your Honor.
2025. All right, sir. All right. Thank you, Mr. Campbell. Court calls the case, People versus Ishmael Davis.
I'm Tom Boyd, assistant prosecuting attorney to the people.
Your Honor.
I sat there, you were sitting there all morning.
I know.
And I go, where is he?
Just
go ahead.
When quick questions pop up,
Yeah, I know.
Your Honor, we are just, this Assistant Public Defender Jay Bellinger on behalf of Mr. Davis. We were just asking to set this for preliminary examination at this time. All discovery is complete to the best of my knowledge.
All right. And would people have their witnesses available the 18th?
We should be able to.
Preliminary examination in person, November 18th, 2025, 9 a.m. That is before Judge Washington. Bond will continue.
We'll be in touch, okay?
Yeah.
All right. Thank you, Your Honor.
Court does call the case of the People versus Dylan Chapman.
Assistant Public Defender Jay Bellinger on behalf of Mr. Chapman, who approached us. Mr. Chapman, can you state your name for the record?
Dylan Chapman.
Thank you. All right. You're requesting an adjournment.
I am, Your Honor. I unfortunately have no discovery in this case at all at this time. I understand they're working with new systems, but we are trying to get that as fast as possible.
November 25th, 2025, 9 a.m. Bond continued. That is Tuesday. All right. Okay.
Thank you.
Thank you, Your Honor.
Court calls case People versus Clinton Donald.
Assistant Public Defender Jay Bellinger on behalf of Mr. Donald. And
Clinton Donald.
Thank you.
Your Honor, this is another situation in which we unfortunately just have no discovery at this time, so I would ask for an adjournment.
Probable cause conference will be adjourned November 20th, 2025, 9 a.m. Bond continued.
Your Honor, if I may just quickly address bond.
You may.
Your Honor, my understanding is that the bond is currently set at $25,000. We are asking for a 10% provision on that. Ultimately, we are asking for a PR if the court would consider it. My client can stay with his mother in Belleville. He can willing to maintain no contact with the complaining witness who lives in Ypsilanti. So he has no reason to go to Ypsilanti. Otherwise, he is responsible for financially supporting 2 children at this time, and he's willing to do a strict home confinement and any other condition that the court feels is appropriate. We are just asking for a 10% provision, if nothing else.
Response.
Reduction in bond. In this case, the 15-year-old child of the victim called the police to say that the defendant threatened his mom. When police came, the victim said she didn't know why they were there. Trying to get the 15-year-old not speak to police, but he told police that the defendant pressed a gun to his mom's head and he was hit. And at that point, the victim refused to let the child enter the house. So I have serious safety concerns should he be released or to be hearing information as well.
Anything else?
Nothing further.
Motion for bond reduction is denied. Bond will continue. Thank you.
Okay.
Court does call the case of People versus Jaqueline Cleaver.
People.
Honor, Assistant Public Defender Alexis Kumar appearing with and on behalf of Mr. Cleaver. Mr. Cleaver, could you say your full name?
Jaqueline Lavelle, please.
Thank you.
Say that first name. Jaqueline. Jaqueline. Okay.
Your Honor, I believe there should be a plea form in the.
There it is. The plea form indicates that the defendant would be pleading to an added count 4 of use of a controlled substance, a 1-year offense. Upon a successful plea to that charge, counts 1, 2, and 3 would be dismissed. That's the court's full understanding of the agreement.
That's correct, Your Honor.
Yes, Your Honor.
May I have him sworn.
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give to be the truth, nothing but the truth, so help you God?
Yes, sir.
State your name.
Jaqueline Lavelle Cleaver. Sir, it is this court's understanding that you're going to plead guilty to the charge of use of a controlled substance. That's a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. Do you understand that? Sir. Still wish to plead guilty? Yes, sir. And to that charge, how do you plead? Guilty. Now, you understand that by pleading guilty, you'll not have a trial of any kind? Yes, sir. You signed an advice of rights form today? Yes, sir. Any question about those rights? No, sir. Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form. Yes, sir. You understand you're giving up your right to appeal of right? Yes, sir. Are you on probation or parole? Yes, sir. Which one? Probation. All right. Were you on probation at the time of this offense? Yes, I was already on. This was a couple of years ago. I was already on probation. This case, just want to check something. All right. So you were on probation at the time of this offense? Yes, I was already. All right. No, I wasn't on it. I caught the case and then it was like PFI, pending further investigation. Okay, so when this case was committed, were you on probation? No, I wasn't. No? All right. Does anybody promise you anything other than what's been stated here today on the record to get you to plead? No, sir. Anybody threaten you or coerce you? No, sir. You're doing this voluntarily? Yes, sir. Of your own free will? Yes, sir. And because you believe that you are indeed guilty of this offense, sir? Yes, sir. All right. On the date of September 24th, 2024, location 2125 Glencoe Hills Drive, Pittsfield Township, Washtenaw County, State of Michigan. Did you have hydrocodone in your or cocaine in your possession, sir? Yes, sir. All right. And did you know you had cocaine? Yes, sir. Had you used it? Yes, sir. All right. And you knew what you were using was cocaine. All right. Sir, if I accept your plea, I do have to advise you that if you commit misconduct as defined under the Michigan court rules between the time of my acceptance of your plea and the time of your sentencing, the court would no longer be bound by any sentence evaluation or recommendation and you would not be permitted to withdraw your plea. You understand that?
Yes, sir.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And have I complied with the court will, and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 4. Counts 1, 2, and 3 are dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be
December 10th at 9 a.m.
December 10th, 2025, 9 a.m. That is before me. Bond will continue. All right, sir. Thank you. Sir, on your way out down the hallway, my probation department is on the left-hand side. Stop in there and just let them know that you'll need an appointment or whatever.
Okay.
Okay? Thank you. Court does call the case. People versus Jason Ellis.
We're set today in this matter for the final pre-trial. This is the court's drop dead date. We do have a speedy trial currently set for 5 days to begin on December 1st, 2025. There are certain things that we do have to handle and take care of here today. As this is the final pre-trial, I'm pulling up the court's scheduling order in this matter so that we can make sure that we go through everything, because it needed to be, everything needed to be done according to the deadlines provided by the court in the scheduling order. I'm going to start with Ms. Perrin. Can you please provide me an update on whether or not you believe that this matter has reached an agreement or is close to reaching an agreement, and you just need a few little moments or other moments to tweak it?
At this point, there is no agreement.
All righty. So anything else that you can update me with regards to your case? Because according to the scheduling order, we do have certain dates that we have to abide by. Because again, this is a speedy trial and we need to make sure that we are ready to go.
So I filed our motion limiting. I believe I filed a letter about our expert, but then
I reviewed that with the DNA expert. Now you're pulling that back. I reviewed your motion in limine. I didn't, in your motion, didn't see anything too different.
Nope.
Okay.
Nope, there really isn't. So, no, Your Honor, there's nothing at this point that I think I really need to raise with the court.
Excellent. Thank you, Ms. Perrin. Ms. Erdman, I'm going with you second because you did file your motion in limine as well as your motion objecting to a lay testimony by I don't even know what kind of the MOCIC. I don't know what that stands for, but that MOCIC employee. And so I have reviewed all of them, and this is the date and time to discuss these matters so that we are all prepared to move to trial. Because again, this is my drop dead date. That means the court will not accept any agreement after this date. That means that if we move forward, either the defendants must plead guilty to all of the counts that are charged against them, or the state must dismiss those counts or some of those counts outright. Otherwise, the matters will proceed forward to a jury at that time, if convicted or for the trial. And then we will proceed later. So Ms. Erdman, this is your time to make any arguments as to your motion.
Judge, I filed both a motion in limine and then a separate motion addressing, I guess, what could be kind of framed up as lay testimony in introducing cell phone site data. I think that's probably the bulk of what would be addressed. So I'll start there. And essentially, I think there's a couple of concerns. So the way that this case came on was a speedy trial demand that I don't know that anyone, myself included, was expecting. So we've all been working hard to comply with the deadlines. We had a conference and the court gave us a scheduling order And in that order, I noted that there was particularly something referenced about making sure that Daubert hearings were heard timely. I kind of gave it some time waiting for the state's witness list, anticipating that I wanted to file one, but didn't see the state's witness list forthcoming. At that point, I just wanted to put everyone on notice, hey, I want to make sure that everyone knows this is an issue. And I think the Daubert issue really came down to whether or not the correct person would be seeking to submit the information relative to cell phone, and kind of based on a lot of the technicalities that are involved, things like whether or not the whether or not the cell phone sites, are on a hill and how that can impact the reception, and the location isn't exact. And there's this concept where a pie chart is typically drawn, which is kind of like a 90-degree angle, and how that really isn't necessarily meant to be interpreted literally, kind of thing. And so I put that Daubert motion out. The state rightfully pointed out I had an error in my motion that had listed I recycled a motion, so the names listed were nonsensical. They weren't applicable here. And I acknowledge that. That was my mistake, and it was just a sloppy mess. And so the motion was out there. The state then responded by email. I don't intend to use an expert. I expect that this will come in under lay testimony and cited a case. And so it was only, I think, 2 days ago or yesterday, I can't remember when I was working on it, that I was able to really sit down and digest the issue. So I apologize for the tardiness. But essentially where I've landed, Your Honor, is that it's an unsettled standard in the state of Wisconsin, whether or not expert testimony is required when introducing cell site data. And the case that was cited by the state is US versus, or state versus Cameron. That's 2016 WIS app 54. And that essentially adopted an unpublished opinion, state versus Butler, 2014 app, AP 1769. State versus Cameron was a case fact pattern where there was a stipulation as to the accuracy of the cell site information. So the data from the cell phone provider was already stipulated to, and it was literally a plotting exercise on a map of taking the latitude and longitude coordinates and applying them to a piece of paper. And in that case, the courts held that it doesn't really require any kind of specialized knowledge, and that it doesn't take an expert to make a map using cell phone tower data provided by the phone company. That was the holding in that case that the state was purporting to rely upon. And so as I've set forth in my motion, there's a couple of things. One, this is not stipulated to information. And two, the attachment that the exhibits that I attached, exhibit 1 is a copy from the provider, it's AT&T in this instance. And there's a couple of cautionary disclaimers at the top. The results provided are their best estimate of the location. Please exercise caution in using these records for investigative purposes. Location data is sourced from various databases, may cause location results to be less than exact, right? So that was kind of the place where we started. And then at the bottom, it's disclaims that it's proprietary information. That's so it's using a compilation technology that they're not willing to disclose to the outside public world. And so, Your Honor, we'll see on exhibit 2 is the data that was put together by the analyst from, or I guess I'm not sure of her position there, but the MOIC person out of, I think it's Missouri is where the lab is located. And I just want to, I guess, call to attention the purported caption or heading of this: all cell sites for calls, data, SMS messages, and time in advance for this phone number for this time period. That's what the exhibit is purporting to show. And then there's a pin where the quote unquote burglaries occurred. So that's noted in the top corner. And so then if you scroll down, there's a second pin that's been added, and that's the area frequented by subject. And if you kind of look between the two, right, if you start at the top and then look to the bottom, the area frequented by subject is not supported. It's not supported by the cell site data. So that seems to be kind of a hearsay, or that information likely came from an alternate source. And then as it goes forward, they've applied the familiar pie shape kind of notations, etc. And it goes into even, broader strokes that way. So what the state, I believe, is saying now in the response that I saw is, well, I can still do this, right? I'm going to just use the AT&T witnesses that weren't disclosed yet, because I reviewed the second witness list filing that was made within the last week or so. There's still no one listed from AT&T to introduce business records, such as the cell phone location data. But the state's saying, I can get around this. And my expectation is I would just call these folks, have them say, this is our business data, this is the detail. And then we've simply just done a mapping exercise. That's how the state's asking to introduce this. The business record obviously will be subject to cross-examination, especially as it relates to the disclaimer at the top. But I think I would pose to the court, even if we've got someone sitting here from AT&T who says that we at AT&T pull latitude and longitude data using various sources that we consider proprietary, but they're databases, and we use that to compile this. And then the state is permitted to take on that mapping exercise. At what point in this process do we hear from someone who can say, but wait, this is something that's next level, this compiling of data at the source involves certain levels of expertise, certain levels of software. Here's how it works, here's how it's explained. And this is why what you're seeing on the map looks the way it is. And I'm sure the state will be very quick to say, but Judge, if the defense wants that kind of information to come before the court, then it's the defense's burden to provide that technical detail. I simply want the ability to take what has been deemed less than exact, that's the words that they use, less than exact data from AT&T. I just wanted to take it and put it on the map, Judge. And if the state doesn't like, or if the defense doesn't like it, then they should bring in someone to tell me why I can't. And I think that it's something that the court really should be aware. The federal courts have held a variety of different ways on this. It's not settled law in Wisconsin. I did give you the cites in my motion that there were some people that were pretty vocal that this needs to be introduced at an expert level, that's at the federal level. But I will also say, in certain instances, under the correct amount of correct circumstances, where there's already either a stipulation as to the accuracy of the data, or at the lowest level, there's just not a lot of contention, that the courts have been open to allowing people to do kind of, I guess, what amounts to a mapping exercise, right? Take and plot, location A here, location B there. But I guess the confidence of the data to begin with this less than exact disclaimer, and then taking it and applying it as they have on Exhibit 2 and saying this represents all data, all sites, all cell sites for the calls, right? And PS, sometimes calls bounce off of one tower to a second tower to a third tower simply because of the way, Your Honor lives in the Northwest. You understand cell phones are not, precise and exact. They don't necessarily always work in certain areas. There's some areas that are better than others. It has to do with topography, etc. So I think it's something that we just, I guess, need the court to be mindful of what's been done in the past. Our urging would be that the court say that this, based on this level of detail, without someone coming in to interpret, it's just not sufficient to be introduced in this manner.
Thank you. Ms. Perrin, I know this is not your argument, but you are a co-defendant or you represent a co-defendant in this case. And so your opinion on this matter, your statement as it relates to your client is important.
Right. I would join Attorney Erdman in her argument, and I can file a motion as well.
You don't need to file a motion as well. I think I will take this as an oral motion to concur and side with the arguments made by Ms. Erdman.
Yes, and she did tell me about it, and we did talk about it the other day. I haven't had time to file anything, but I did review the federal and the state cases. I agree the federal cases do support not allowing the state's witness to testify about this, and I agree that this Wisconsin state law is not settled in this area.
All right, thank you. Mr. Schmidt.
I have two main thoughts on this topic. One, I don't know how the court could accept the arguments by the defendants without just completely eviscerating everything Cameron stands for. When I look at paragraphs 25 and 26 in Cameron, they specifically address this exact argument. This was the argument put forth to the Cameron court. They talked about what the experts said about accuracy and reliance and mapping. And at paragraph 26, the Cameron court says all that stuff, it goes towards the weight of the evidence of the cell phone location mapping, not to the admissibility. So I think what the court is hearing right here is not an argument that this evidence is inadmissible for some reason, because they are admitting it's layperson testimony. They are not saying this is Daubert.
Chairman Judge, on behalf of Mr. Ellis, who is approaching. Take your name for the record.
Jason Ellis. Thank you.
Your Honor, we are asking for an adjournment pursuant plea negotiations. We'll also be submitting a motion to have Mr. Ellis be released into treatment.
Probable cause conference will be adjourned November 20th, 2025, 9 a.m.
Your Honor.
And will continue. Thank you. Court calls case People versus Andre Collins.
Ready now.
Minnesota Water Assistant Prosecuting Attorney for the People.
The long ground deputy chief public defender appearing on behalf of Mr. Collins. Not appearing by Zoom. I have paged the courtroom and the hallway. I've received no response from Mr. Collins, although I do know that he has housing security issues. And in contact with him earlier in the week. He indicated he understood date and time and place, but he's not here. I have no explanation for that. I'd ask that if the court issues a bench warrant, that they delay it so that we can try to contact him.
Bench warrant will issue bond, 10,000 cash surety. I'm going to have that issue immediately. Don't worry. Let's see, there it is. I'm just happy you didn't ask me for a show cause.
That was going to be. I forgot about it.
Court does call the case People versus Eric. Is it LZ Williams?
Minnesota Water Assistant Prosecuting Attorney for the People.
Assistant Public Defender Sandra White on behalf of Eric LZ Williams.
Your name, sir?
Eric O. LZ Williams.
Thank you.
And I'm looking for my green sheep, and I am asking for an adjournment in this matter, Your Honor.
You're probably the same pace in a second release there. Did you get, hang on, did you get him up to us?
I did.
She did?
Yes.
2? She probably owes us 5. Probable cause conference in this matter will be adjourned to November 20th, 2025, 9 a.m.
Yes.
Bond.
May we address bond?
Go ahead.
Thank you. We're asking for a home confinement tether. Mr. LZ Williams does have a job at Tyner Furniture where he works from 8 to 4:30. He has 4 kids. He will abide by all bond conditions. And with the bridge cars currently being cut off, his family is struggling. His criminal history consists of a driving while license suspended and operating while intoxicated. And these are his first felony allegations, although serious. At the time that they happened, he was very cooperative with the police. So we are again asking for a home confinement tether.
Response.
People would check this, has actually several operating while impaired, but the bigger concern is the allegations here. The allegations are that he fired off several shots either into the air or at a bush. There's some dispute as to where he fired them off. These occurred at his home. So I don't see how home confinement is going to protect the people who live there. I would ask that the people would object to any change upon.
Anything else?
Would Your Honor consider
You
lowering?
have a different address though.
We
in
could,
Wayne.
he can reside in Wayne, Your Honor.
The charges as I have them, I understand what the people just said was, but there was a discharge of a firearm toward a building or dwelling which was occupied.
Or in
The building. Got it. Motion for bond reduction, given the circumstances and seriousness of the case, if denied, bond will continue. I think it's appropriately set. Thank you.
Thank you, Your Honor.
Court does call the case People versus Christopher Coyle.
Assistant Public Defender Jay Ballinger on behalf of Mr. Coyle, who approaches. Mr. Coyle, can you please state your name for the record?
My name is Christopher Coyle.
And Your Honor, we are asking that the court consider a 1-week adjournment on this. As far as we're concerned, the case got negotiated late, so it is resolved. It'll resolve under 4A, so we just need to drop the paperwork for the court. So we're just asking for a very short adjournment, if possible. Because you like me.
I do, but I like everybody, so it shouldn't mean anything.
It does, though. It does.
Probable cause conference will be adjourned to the 13th.
Thank you, Your Honor.
13th, 2025, 9 a.m. All right. Bond continued. Thank you.
Don't leave yet. Wait for me out there.
Court does call the case People versus Christopher Fair. Fair.
Oh, I heard prayer, my bad. Raymond.
No, that's what I was doing. It wasn't what I said, but.
Ron Brown appearing on behalf of Mr. Fair, Your Honor.
Your name, sir?
Christopher Fair.
Thank you.
Your Honor, did you get my green sheet request?
I did. Probable cause conference will be adjourned November 20th, 2025, 9 a.m. Bond continued.
Thank you.
Thank you.
Comes.
Court calls case People versus Moses Cunningham Page.
Assistant Public Defender Jay Ballinger on behalf of Mr. Coonigan Page, who approaches.
Your name, sir?
Moses Cunningham Page.
And Your Honor, up to this point, I haven't been able to make contact with my client. I did get good contact information for him. A couple other things I need to look into, so I'm just asking for a 3-week adjournment if possible.
All right. I will adjourn this to November 25th, 2025, 9 a.m. That's a Tuesday. Okay.
Thank you, Your Honor.
Will continue. Thank you, sir.
Thank you.
Don't leave before I give you this, okay?
Court calls case People versus David DeLucia.
Senator Water, Assistant Prosecuting Attorney for the People.
Chief Public Defender appearing on behalf of Mr. DeLucia. today is the date and time set for the probable cause conference. I believe this is an adjournment request. Does the court have the green sheet?
I do not have it, but
I'm here. Thank you.
you're requesting an adjournment.
I am, and I want to address bond.
Your name, sir?
David DeLucia.
Thank you. All right. Probable cause conference will be adjourned November 20th, 2025, 9 AM. Yes, as the bond.
Yes, Mr. DeLucia I'm sorry, I'm looking for the green sheet, but I'll do that in a second. Turned himself in when he got out of prison to handle this matter, a matter he wasn't allowed to handle in prison. He's always attended his court date. He has stable housing. He has a support system, his mother and father. He found out about other matters while in custody and he wishes to handle those matters. He's currently on disability, so he isn't working, but he wants to continue to get help while out of custody. He has shoulder surgery in April, and currently his shoulder is not in good condition. So we are asking for him to either have a PR bond or 10% on his current bond.
Response.
The allegation in this case is that he stole over $2,000 worth of jewelry, and then when he was approached by an officer outside, the officer told him to stop repeatedly. He repeatedly refused to do so. The officer then tased him, put him to the ground, and continued to resist. He tried to remove the bars to his large size. The officer did not want to get into a physical altercation with him. Based on those allegations, people are concerned that he will not comply with these court's orders any more than he complied with the officers. And he did also just get off parole as counsel indicated.
But he successfully completed parole?
He successfully completed parole, Your Honor, and probation.
But when did he complete parole?
March of this year.
So, and then within basically 6 months, this happened, or allegedly does.
It was a slip up, Your Honor.
Pardon?
It was a slip up, but well, allegedly a slip up. Thank you. Allegedly.
Well,
We're willing to.
that, I think if it causes a problem, I'm actually looking at his bond, given the release from parole and then the circumstances, at least as they're described by the people, I'm surprised that his bond is actually set as low as it is. But I'm not going to raise it. I'll leave it where it is. But motion for bond reduction is denied. Bond will continue.
Thank you, Your Honor.
Thank you, Your Honor.
Court calls the case People versus Amiri Davis.
Assistant Prosecuting Attorney for the People.
Assistant Public Defender Jay Bell on behalf of Mr. Davis, who appears via Zoom. Mr. Davis, can you please state your name for the record?
Hello, Your Honor. My name is Amir Davis.
Amir. Okay.
And Your Honor, after speaking with the prosecution in this case, it sounds like we may be able to resolve with some misdemeanors. I was able to make contact with Ms. Foster Tucker with regard to her scheduling in terms of keeping all these cases together if the court prefers to do that. I was not, however, able to get a hold of Mr. Quinn, so I don't know his schedule, but I don't know if the court.
I only have one case before me.
I understand there are co-defendants in this matter, Your Honor.
Oh,
I apologize.
Okay.
And those co-defendants are Mr. Davis's brother and E. Williams. I don't know the first name. I'm sorry. I don't have it.
Earl Williams.
Earl, thank you.
All right. So you're looking, okay, gotcha.
Aaron Davis.
And my understanding is that Ms. Foster Tucker's plan is to adjourn this as well.
All right. Then I'll adjourn this to November 25th, 2025, 9 a.m. That's a Tuesday. And if the people could just let me know when the others are called up and we'll put them over to that same date. Bond will continue.
Thank you, Your Honor.
All right, thank you.
Thank you, Your Honor.
Court calls case People versus Brian Gerard.
Morning, Your Honor. Raymond Cook from People.
Your Honor, Alexis Kumai, Assistant Public Defender, appearing with on behalf of Mr. Gerard, who's approaching. Mr. Gerard, could you say your full name?
Brian Gerard. Thank you.
Your Honor, I do have a green sheet here, as well as a stipend order to allow the treatment, if you would consider it. And we are just requesting a very brief adjournment so that we can work out a resolution.
I don't have a problem releasing him to treatment, but he would need to be on a tether.
Understood. No objection to that, Your Honor.
Well, okay, good. So if I won't sign this order, if you could include that in the order to me, then
Yes, I
don't have a
will
problem.
update it.
All right. And you wanted an adjournment on this, so
Yes.
I'll adjourn probable cause to November 20th, 2025, 9 a.m. Bound will continue.
Your Honor, maybe briefly approach on this.
Fine. You did so well. What? Agree. The 1 year offense upon a successful plea to that charge, count one would be dismissed. That's the court's full understanding of the agreement.
That's correct.
Yes, sir.
May I have him sworn?
Right here. Do you solemnly swear to affirm the testimony you're about to give the whole truth and nothing but the true self you got? Yes. State your name. Harold Orson.
All right, sir. It is this court's understanding that you're going to plead guilty to the charge of retail fraud in the second degree.
Yes,
That is
sir.
a misdemeanor, punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that becomes the maximum fine. You understand that?
Yes, sir.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valvo in the 15th District Court. You understand that?
Yes, I thought it was this.
Pardon?
I thought it was, okay.
Yesterday, what could be the Perry without them?
Okay.
Okay. You understand that,
Yeah,
sir?
I understand. I just been going to this court, so I didn't know. She's just telling me about going to this new court.
Yeah, we're sick of you. No, all right. No, you understand Judge Valvo would be handling the
Yes, sir.
sentencing in this case, although I'm taking the plea. All right. Understanding all of that, do you still wish to plead guilty?
Yes, sir.
All right, to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
All right, you signed an advice of rights form, is that correct?
Yes, sir.
Any question regarding any of those rights?
No, sir.
Please look at paragraph 5 on that form. You'll see a copy. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, sir.
of your own free will,
Yes, sir.
and also because you believe that you are indeed guilty of this offense, sir?
Yes, sir.
On the date of March 4th, 2025, at the location of 254 Briarwood Circle, City of Ann Arbor, Washington County, State of Michigan, that being the Sunglass Hut, what did you do that makes you think that you're guilty?
Took a pair of glasses.
You did what?
Took a pair of glasses.
You took a pair of glasses and
Yes,
you
sir.
tried to walk out without paying for them?
Yes, sir.
All right. And the value of those,
I believe they were like $200.
was it in excess of $200?
It was about $207.
All right. And the store was open to the public at the time?
Yes, sir.
You didn't have anybody's permission to take that property?
No, sir.
And this property you took was property that was offered for sale by
Yes, sir.
them? Those ones that you put on the podium, those aren't the glasses, right?
Oh, no.
No, okay, I'm just,
No.
okay, I just thought I'd ask. Sir, I do have to advise you that if between the time of my acceptance of your plea and the time of your sentencing, if indeed you commit misconduct as defined under the Michigan court rules, you would not be entitled to any sentence evaluation and or recommendation, and the court would not be bound by that. And you would not be entitled to withdraw your plea. You understand that?
Yes, sir.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this?
None of the people are aware of.
No, Your Honor.
And have I complied with the court rule, and would it be proper to accept this defendant's plea?
People are satisfied now.
Defense is satisfied.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing will be
December 2nd at 9 a.m.
December 2nd, 2025, 9 a.m. That is before Judge Valwell. Okay. Bond will continue. Okay?
Thank you, Your Honor.
Court does call the case of the People versus Taiwan Griggs.
Kenneth Overwater, Assistant Prosecuting Attorney for the People.
Second again on behalf of Mr. Griggs. Mr. Griggs, would you please state your name for the record?
Taiwan Griggs, Grand Rising. Hello, Mr. Griggs. She actually was Taiwan Dominique Griggs.
Okay, sorry. Thank you, Your Honor. I have forwarded some mitigation information to the prosecutor in this case. I'm asking for.
I guess it's a preliminary exam.
We're going to set it for a preliminary exam, Your Honor.
Both of them?
Yes, Your Honor.
Is all discovery complete?
Yes, Your Honor.
People have their witnesses available the 18th.
I expect we shall.
Preliminary examination will be set November 18th, 2025, 9 a.m. before Judge Washington.
Your Honor, can we address bond? I do believe the last time we were here, the court was, or the prosecutor's office believed new charges were coming. It's my understanding those new charges have been brought to the court's attention in case 25 F5-5267. Anything else?
Say which ones?
I believe it's in 25 F5-5267 would be the new case.
Got it.
That is correct.
And Your Honor, as supports where my client does have a substance abuse issue, you said you would consider it. I can prepare an order and I will prepare an order if the court is inclined to allow him to go to treatment.
I don't have a problem with that. Needs to include that there's a tether and that he will be returned to the jail if he doesn't complete.
Perfect, Your Honor. I'll get that to your honorable court.
So preliminary examination, the 18th, before Judge Washington. And bond will continue, and I'll sign that order when it comes.
Thank you, Your Honor.
Thank you. Court calls case, People versus Daryl Gardner.
Assistant Public Defender Hannah Apple, Mr. Gardner. State your name for the record.
Daryl Gardner.
Your Honor, Mr. Gardner is asking that this matter be set for a preliminary examination.
Did you want to deal with his violation first, or what is this?
I got this.
I don't know. That's something said. I signed in at the thing. The money to pay him, so he wouldn't let me test.
We have to get the money.
I'll get it. They got me scheduled to come up there Monday.
This coming Monday? Okay. Your Honor, Mr. Gardner reports that he's scheduled to go back to community corrections for his intake and be able to pay for testing on
When?
Monday.
Yeah. When is he scheduled to go back? Mr. Allen?
He reports that he is scheduled to go back on Monday.
When was that done?
When did you schedule that?
The day after I got out of jail, I went right up there.
Talked to her this morning, correct?
I think so. I talked to somebody this morning on the phone on the way here. I don't know who it was though.
Yeah, that's Agent Dozier, I believe.
Oh, yes, the agent, yep.
Did you schedule that with her today?
No, I scheduled it with the lady that I saw when I went up there. She scheduled it for some agent for Monday coming up.
Your Honor, as the report indicates, looks like he talked to Agent Dozier this morning regarding that. He reports that he's scheduled to report on Monday for
Why didn't he
testing.
go in before?
He
Well,
reports that
his indications of what he said to community corrections are very disturbing to me. Because it's an absolute lack of cooperation.
They said
what made him supposedly call this morning? Because that would normally have been included in here. It's not included in here. And we received this communication regarding the violation at 9:32 this morning. So if he had an appointment, I'm sure they would have let us know. The witnesses available the 18th.
Yes, sir. Talked to Agent Dozier this morning.
I talked to somebody on the phone, yes. I don't know their name. I was on the bus on my way here.
Your Honor, that's all the information that I have to present to the court is what's in the report. And he states that he had a phone call with Agent Dozier this morning regarding his non-compliance.
And he's telling me that he's set for an intake on Monday?
Yes.
Yes.
Preliminary examination will be set for November 18th, 2025, 9 a.m. That's before Judge Moore. This time, what I have here is a violation. And at this point, you haven't been over to test at all since your release.
Yes, I did. You
haven't submitted a test.
I didn't. I tried. They wouldn't let me. They told me because I didn't have the money, they wouldn't test.
Bonds revoked, defendants remanded. If we find out additional information, then maybe I'll reconsider that.
Your Honor, I'll reach out to Agent Dozier just regarding that.
Court calls the case of the People versus Barack Howell.
Your Honor, Alexis Plumai, Assistant Public Defender, appearing with and on behalf of Mr. Howell, who is approaching. Mr. Howell, could you say your full name?
Hello, my name is Barrick Howell.
Thank you.
Hi.
Your Honor, I do have a green sheet to turn over. I am just requesting a brief adjournment. Weeks. Mr. Howell unfortunately was not accepted to mental health treatment court, so I am working on an alternate.
Alternate plan. All right. Without objection, probable cause conference, November 20th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
Thank you. Court calls case of the People versus Aaron Grable. It's your fault.
What? I wasn't even
No,
here.
I know. You should have been here to catch the cop.
Michael Gaddy, Assistant Public Defender, on behalf of Mr. Grable, who's here via Zoom, Your Honor.
Mr. Grable, can you state your name, please?
Aaron Grable.
All right, what are we doing?
Your Honor, I have submitted a green sheet. I'm asking to adjourn this matter 2 weeks. I have spoken with Mr. Overwater. I think a resolution is in sight. I'm going to provide some more information to him and let him follow up on that, but I think we're well on the way to resolving this.
November 25th, 2025, 9 a.m. Without objection, bond will continue. That's excused.
Thank you, Your Honor. I'll get you call when I'm out of court, Mr. Grable, okay?
All right.
Thank you, Your Honor.
Okay. Court does call the cases of the People versus Dale Miller.
People.
Ron Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Dale Miller, who approaches. Mr. Miller, when you're ready, please state your name for the record.
Dale Joseph Miller.
Honor, today's in date and time set for competency review. Is the court in receipt of the letter from?
Yes, I'm received from an October 24th submission to the court.
We have no further evidence to present to the court.
Your Honor, people have no further evidence and stipulate the use of that report and ask the court.
All right. This time, based upon the review of that report, the defendant would be deemed competent. Court will order so that the defendant now can understand the nature of these proceedings and the nature and objects of these proceedings and can rationally assist in the defense. Therefore, the defendant is deemed competent.
Thank you, Your Honor. We will prepare orders to that effect.
Today.
Yes, we'll have top people.
Okay. And what would you like this set for next?
As soon as possible. Okay. Probable cause conference.
Probable cause conference. Set probable cause conference in this matter then for November 20th, 2025, 9 a.m.
November 20th. All right. Let's see.
Bond will continue.
Thanks. Thank you, Your Honor.
Thank you. Court calls case People versus Alicia Cargill.
Good morning, I'm Rob Chico on behalf of Ms. Cargill. Judge, this is a situation. This case has been going on since August. I've had several visits out at the prison with her. I don't think her earliest release date is till for another 9 years. I've sent her all the discovery. She was insistent on seeing the video. I had a visit set for 8 a.m. this morning. I was told by prison officials she did not want to see me today. Speaking with her, I know she's objecting to the police report, which we went in detail. Can I just set an exam in this matter, Judge? And can we?
Well, I need her here to set an exam. They signed in, she would not come to the room. And then eventually the facility signed out.
What should we do?
Well, I'm going to adjourn it over. I mean, if she doesn't, then you have to figure out something if she doesn't want to participate, but I'm not going to just set it for an exam if the defendant's not participating or is not here.
Okay. Can we adjourn it out to the 20th?
Well, they're going to have to do a new writ and they're going to have to make sure that she's going to actually participate in this. I'm not going to have everybody go through work and her just decide she's going to try to do it her way. So you'll have an opportunity to talk with her. I'll adjourn this at this point out to December 4th, 2025, 9 a.m. And that doesn't interfere with the defendant's release on anything because she's not going anywhere.
Okay. All right. Thank you.
Thank you. Court calls case People versus Renee Hall.
Morning, Your Honor. Raymond Cook to the people.
Ron Brown appearing on behalf with Ms. Hall.
Your name, ma'am?
Renee Hall.
Thank you.
Did you get my green paper?
I did, Mr. Brown.
We're requesting.
Unlike Shanaza, yours are right on time.
Thank you. We're requesting adjournment. The co-defendant is Mr. Gay, Thomas Gay. So you want to do the same date?
What date was that? 25th. Yeah, like that.
Thank you.
All right. Probable cause conference will be adjourned November 25th, 2025, 9 a.m. Bond will continue.
Thank you.
That is a Tuesday, by the way.
Oh, Your Honor.
No. What? What were you going to ask? You were going to ask to approach?
Yes, very briefly.
That never's the case with you, Brown. Come on.
Yes.
Thank you.
Thank you, Your Honor.
You're welcome. Court calls the case People versus Ryan Phelps. Two cases.
People.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Phelps, Your Honor, who's here to my right. State your name. Phelps?
Ryan Matthew Phelps.
Thank you. You're asking for an adjournment?
Yes, Your Honor. We're still trying to reach a global resolution in this matter. I have discussed the potential with Mr. Mayville of a potential release to treatment, and I will draft an order and submit it to Your Honor for review.
All right. Did you want me just to put, I mean, I normally put it out 2 weeks, but you're trying to get into a specialty court, and I know they're not operating that quickly, but I mean, I'll give you whatever date if you're trying to get in there.
Your Honor, if we can maybe set the 2-week date, and if need be, I'll adjourn it by stip and order or very early.
Probable cause conference, November 20th, 2025, 9 a.m. On continue.
Thank you, Your Honor.
Court calls the case People versus Suzette Hampton.
Ash Fox for People. Not carry. I can move your eyes. I put Miss Suzette Hampton here. She was here. She was walking outside because she needed to ease herself.
You told me that it was going to get better.
I've got my green sheet. You see, I was back there
You got a
talking to
green sheet
Mr.
and
Brown.
client. Good.
I'm fighting for my life here, Judge. Can we just pass it? I told her
No, every Thursday I have to pass one for you. Why is that?
Judge.
Sorry. No, you're not. I'll pass it.
Thank you so much.
Court calls the case People versus Daniel Sims. Yes, he is. I'm like, Miss Akinrilistein, we know where he is.
Client control, Judge.
Wow.
Not directed at me.
No, that was specifically directed at her.
No.
In fact, I heard the
Mr. Kidd, does your client wish to have a hearing?
He does not, Your Honor. He's prepared to admit to the violation.
All right, Mr. Kelly, you understand you are entitled to have a hearing?
Yes, sir.
You wish to waive that hearing and admit to the violation?
Yes, Your Honor.
All right, the court's going to find that you have violated the terms of your community control. It's my understanding that you have 272 days jail time credit at this time. I'm going to order you to serve 272 days in Warren County Jail with credit for the 272 days you have earned, and the court is now going to terminate you from community control. We'll note that as a neutral termination.
Thank you, Your Honor.
Any questions?
No, thank you, Your Honor.
All right, that's all. This is case number 25-CR-42736, the State of Ohio versus Jennifer Wilson. Ms. Wilson is before the court with counsel Mr. Cicero and Ms. Tranter on behalf of the State of Ohio. We are here. Court had previously made a finding of that the defendant is incompetent but restorable. The least restrictive placement was determined at that time to be in the community. However, there has been a development that we won't go into any detail. Counsel, as everyone's aware of what happened, so the court is going to modify that and find now that the least restrictive placement for restoration is Summit Behavioral Health. The state will also include in the entry that we will look at Appalachian Behavioral Health, which whoever has a bed date available, and also allow access to the Warren County Jail by the state. It's not state.
Forensic Mental Health Navigator.
forensic mental health navigator. So we hopefully can begin restoration at the jail before she's even moved to Summit. Okay? Anything else, Ms. Tranter?
No, Your Honor, thank
Mr.
you.
Cicero?
No, thank
All right, good to see you, sir.
you. You too.
Bus running over. Mr. Brown, did you state your appearance?
Ron Brown appearing on behalf of my client.
Your name?
Daniel Sims.
Thank you.
You get my green paper?
I did.
Okay. Requesting adjournment, Charlie.
You didn't say the reason, but how much time did you need?
Can we get the November date?
Seriously?
Aren't you using the 25th?
Okay. There are three dates left in November.
Yes, sir.
So which
I didn't want to rush.
Do you want the 25th or the 20th?
We'd take the 20th.
The 20th?
Sure. Thank you.
Can I have the November date? Really? Probable cause conference will be adjourned November 20th, 2025, 9 a.m. Bond will continue. Thank you, Mr. Sims.
Yeah, thank you.
Court calls case, People versus Robert Harris.
Cover Maybell for the people. Ron Brown appearing on behalf of Mr. Harris, Your Honor. We're requesting adjournment. And may I approach with an order signed, stipulated order signed by the prosecutor?
Your name, sir? Robert Harris. All right.
May we approach?
Yeah, what's the order? Is it treatment?
You're going to want to see it, Judge.
Okay. Yes, sir. Fall into what Brown asked for. What I'm gonna do is I'm gonna turn it to December 18th, 2025. Let's see where
A
we're at
week
at that
before
time.
Christmas?
What?
Thank you, Your Honor. Thank you. December 18th.
I'll put it on Christmas and just suit me and you.
Now, you know about the Grinch.
Thank you, Your Honor.
Thank you, Your Honor. I get that order to you.
Wow. Did you call me the Grinch?
No, I'm smarter than that.
Yeah, I heard it. That's what I'm hearing. Yeah, you better get out of here. Wow. I could be, except my heart would not grow 3 times too big. Court does call the case of the People versus Dontrell Smith.
Cash calls for the people.
Mr. Smith.
Your name, sir?
Charles Smith.
Your Honor,
Requesting an
we're
adjournment.
asking for adjournment, yes, for AIM referrals and a moment to address bond, Your Honor.
If I do the 20th, will that give enough time to
I would put it out further than that.
further than
Yes,
that?
please.
All right. Probable cause conference, I will adjourn it into December 4th, 2025, 9 a.m. All right, as to bond.
Your Honor, we were going to be asking for a reduction in Mr. Smith's bond. Mr. Smith does have another case in 50 District Court, but I believe they're also going to be requesting.
In which court?
15. It's just a misdemeanor there. It's an older case. Mr. Smith is from Fort Wayne, Indiana. He has family that lives there.
Can I, before you continue to go on, has he posted the other bonds?
No, I don't believe he has, Your Honor.
Is he going to be able to post those?
I believe they were waiting on this case to perhaps let him out for them to address bond, since this is the bigger deal case.
The only reason I'm asking that is because his bond is set at 1,000, 10%. And
I'd be asking.
it's like holding him. I mean, it's like they gave that bond just because he's incarcerated elsewhere.
On another case. Was it to convert to a personal recognizance bond, or was it just a low cash bond?
I wasn't there.
Okay.
I'm looking at the paperwork and it just says.
Okay.
Ms. Feltes, you wanted to say something?
Your Honor, my understanding is at the time of his arraignment on October 1st, we did request a $3,000 cash surety bond with no 10% with flood risk concerns. The defendant home address is in Indiana, and he had cases and or warrants out of multiple states, Pennsylvania, Ohio, Indiana, New York, and Michigan. So we were concerned about
The whole rest belt.
Your Honor, in that case, we'd prefer to keep him in Washington on the low cash bond.
And we
No
don't currently have the warrants in those cases, but that's my understanding is that on October 1st, that was our request for those reasons.
Oh. Anything else?
Nothing further, Your Honor.
Okay.
Thank you.
Most for bond reduction is denied
Thank you.
in this case. Bond will continue. Thank you.
Your Honor.
I did. Court calls case of the people versus Carol Holland.
Assistant Public Defender Jay Bellinger on behalf of Ms. Hollins, who approaches, Your Honor.
Good morning, Your Honor.
Good morning, ma'am. I know, finally they helped you with the door. Nobody was helping you. No, you two ought to be ashamed. Your name, ma'am?
Carol Hollins.
Thank you. You're requesting an adjournment.
I am, Your Honor. Sounds like we may be able to resolve this with a misdemeanor eventually. I just need to collect some mitigation information. So I'm asking for 2 weeks. I think that would be sufficient to cover everything we need.
Probable cause conference will be November 25th, 2025, 9 a.m. That is a Tuesday.
Thank you, Your Honor.
Bond will continue. All right. Thank you, ma'am.
Thank you.
Okay. Here you
Court
go.
calls case people versus.
Now I'm ready. Go for the lead.
Yep.
Morning, Your Honor. Mike Gaddy, Assistant Public Defender on behalf of Mr. Stamper. Sign.
Sir, state your name.
Jesse Stamper.
All right, what are we doing?
Your Honor, we do have a resolution. I've gone over his rights with him. I'm just having Mr. Stamper sign the sentencing judge waiver in the plea form. Fill that out. Yes, Your Honor. It's a guilty plea to a use, Judge. There is no sentencing or plea agreement. I have. And Mr. Stamper is currently on probation, but the probation, it's a little unusual. The probation predates this charge, but the date of this incident is before the probation, but I think he should be okay. I have gone over his rights with him.
plea form indicates he's going to plead to the charge of use of methamphetamine, the 1-year offense. On a successful plea to that charge, count. That's the court's full understanding.
That is our understanding as well, Your Honor.
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name.
Jesse Saper. Sir, it is this court's understanding that you're going to be pleading guilty to the charge of use of methamphetamine. That's a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court cost. Do you understand that? Yes, sir. You also understand that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Barr in the 1482 District Court. Do you understand that? Yes, sir. Still wish to plead guilty? Yes, sir. And to that charge, how do you plead? Guilty. Now, you understand that by pleading guilty, you'll not have a trial of any kind? Yes. All right. You signed an advice of rights form, is that correct? Yes. Any question regarding any of those rights? No, sir. Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form. Yes, sir. You understand you're giving up your right to appeal of right? Yes, sir. Are you on probation or parole? I'm on probation. All right. Were you on probation at the time of this offense? No. All right. Has anybody promised you anything other than what's been stated here today to get you to plea? No, sir. Anybody threaten you or coerce you? Nope. You're doing this voluntarily? Yes, sir. And of your own free will? Yes. And also because you believe that you are indeed guilty of this offense, sir? Yes, sir. On the date of July 4th, 2022, at the location of 724 North River Street, City of Ypsilanti, Washtenaw County, State of Michigan, did you have methamphetamines in your possession? Yes, sir. Had you used them? Yes, sir. Did you know what you were using was meth? Yes. All right. Sir, if I accept your plea, if between the time of my acceptance of your plea and the time of sentencing, you commit misconduct as defined by the Michigan court rules, you would not be entitled, nor would the court be bound by any sentence recommendation or evaluation, and you would not be entitled to withdraw your plea. You understand that, sir? Yes, sir. Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Judge.
And have I complied with the court rule?
People are satisfied.
Defense is satisfied.
The court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 1482 probation. Sentencing in this matter will be December 10th, 2025, 10 a.m. before Judge Barr.
Thank you, Your Honor.
Thank you. Bond continued.
Thank you, Your Honor.
Court calls the case of the people versus Amanda James.
Trevor Maybell for the people.
Assistant Public Defender Hannah Apple standing in for Ms. Plumai on behalf of Ms. James. Your Honor, my understanding is that Ms. Plumai spoke with Ms. James earlier today. We understand that there's a current warrant out. She did turn herself into inpatient treatment. Unfortunately, we don't have verification of that. She reports that she's inpatient right now today, that she's in group. Oh, you're back. That she's in group treatment and that if allowed, she could appear from treatment at the 12:30 time block. That's what we
That's all
got.
correct.
When did she go into treatment?
She did not specify the exact date. She did send our office a message when we had reached out to her originally after the warrant was issued, and she stated that she was checking herself into inpatient treatment. We hadn't been able to get a hold of her since then, but she did send an email to our office this morning stating that she is in treatment. I responded to her and asked if she could potentially appear over Zoom to show the court that she is actually in inpatient treatment. She did respond to me just a little while ago and stated that she is in group until noon, but could appear anytime after.
Well, there's a current warrant that's still out because she's not presented herself to the court. So I'm going to leave the no bond warrant out. I'm not setting another date for her. Somehow or another, she's going to have to get herself before the court. Thank you.
Got it.
Court calls case People versus Raphael Starks.
Prosecuting attorney.
And Stephanie Cannon on behalf of Mr. Starks, who is approaching. Mr. Starks, when you are at the lectern, could you please state your name for the record?
Yep, Raphael Starks Jr.
Your Honor, in this case, we are asking for a 2-week adjournment for mitigation purposes.
November 20th, 2025, 9 a.m. bond will continue. Thank you. So, Ms. Cannon, how come I saw you talking to your intern
What?
this morning?
Your Honor, I didn't, she's here.
I know. Well, how come she hasn't been allowed to do anything?
So what
You are
happened?
so restricted.
No.
She did a fantastic job the last time.
And she is
And
going to
you
do.
won't let her, no, I'm not.
She has
talking
to
to
be, she
you.
has.
No, I'm not talking about. Court calls the case, People versus Serrano Johnson. Serrano Johnson.
Kenneth Overwater, assistant prosecuting attorney. People.
See, finally, when I say, then she lets her come up.
Follow court orders, Your Honor.
That's your forte. All right.
Good morning, Your Honor. Ronica Glenn requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Assistant Public Defender Stephanie Cannon.
Gladly, permission is granted. It's nice seeing you today.
Thank you. It's nice to see you.
Not from like up close and not from a distance where she was hiding you.
Thank you.
Permission to practice is granted. Sir, your name?
Sir.
$11.14 if you get detained there. Start, if you decide to stay a little bit more in New York and spend all your money. That's where.
Your Honor, thank you.
It's a beautiful city. My daughter resides there, but boy, you got to bring your wallet.
We went upstate.
Okay, well, it's still not cheap. Okay,
Judge, I apologize. I was in the other room and I had a call and
it's fine.
I'm
Worry,
sorry.
no worries, no
You got a
worries.
great court officer, so he let me know that.
Well, let's not overstate things here, okay? He is a great court.
It's a job with us.
I'm just messing with you. Dylan James Hall, 25B148235, A and B. Let's see here. A and B. All right. Sir, your name? What's going on, Mr. Hall?
Not about this.
All right, let me just arraign you. You got a charge here that you failed. You have two charges. You have a possession of a controlled substance charge. I sentenced you July 30 of 25 on that and also on concealed weapon charge. And I ordered you to do 8 hours of community service on those.
Yes,
by September 15th, and I have two charges, one on each file. That allege the same thing, that you didn't do it by September 15 of 25. You don't have any prior technical violations. If you plead guilty or if you're found guilty, you could get 5 days. Do you understand that?
Yes, sir.
All right. Did you sign, read, and understand the advice of rights?
Yes.
If you plead guilty, you'll be giving up all those rights. And there will not be a hearing or a trial. Do you understand that?
Yes, sir.
All right. You have the right to an attorney. If you want one, I'll be happy to provide you with one. Do you want a lawyer?
Yes, sir.
I'm sorry?
Yes, sir.
Okay. And then we're not guilty plea. We're going to send you out in the hall. And then you're going to come back in here after you've talked to your lawyer, all right? With your lawyer. Do you understand that?
Yes, sir.
So I'm entering not guilty, please, just for the record. You know what? I'm still gonna need one more probation order, please. I mean probation, arraignment sheet, whatever we call them. So you can go out in the hall. We'll set you up with a lawyer. No, this one here.
Oh, that?
Yeah.
You know, for a
So do you understand what I'm telling you, sir? Either way, you're coming back in front of me. Yeah, that's perfect.
I got it.
All right, good luck. Thank you.
Thank you.
All right. All right, people versus Leah Devon Boozer. 25T6444894. Your name, ma'am?
Leah Boozer.
You're charged with failure to pay $213 on a child restraint charge. If you plead guilty or if you're found guilty and I find that your failure to pay was not without your fault, you could get 1 day jail for every $10 owed. So you could get 22 days. Do you understand that?
Yes.
You can satisfy that in full by payment, in full by serving the jail term, or in part by payment, in part by serving the jail term. Do you understand that?
Yes.
Do you work?
No.
Can you pay this today?
No. But I was coming because my kids are too big for a car seat.
Oh, hang on. You went into default. I'm not going to relitigate this case.
Okay, I don't call to make a court date. Can't call to make a court date. You guys have an answer machine. Then finally I got court date.
And then you didn't show up, right?
This is the court.
No, this was
I got a piece of paper.
Boy, the United States Postal Service must have issues. Lisa, would you please tell me what was sent to Ms. Boozer? You still live on Ropp Street?
Yes.
Okay. Can you please tell her what was sent to her?
Yeah, we don't have a request for a court date. She defaulted August 6th. 20% late fee went on September 25th, collection letter October 1st, and then show cause November 6th.
Yes, and I have been calling. You guys have the answer machine service to do a court date. I'm pretty sure you guys have me on the answer machine about 10 times.
I'm sorry, you left 10 messages?
Yes. Ever since this ticket, I've been trying to get court date.
I'll tell you what you do. Go get your phone bill. No, I want to see the calls that you, just please listen.
Okay.
We don't make mistakes like that here.
Yeah, okay.
Okay? So if you want to go back and you want to get your phone bill that shows that you called the court 10 times,
Okay.
I'll be happy to set aside the default right then and there on the, just wait a second. Right there on the spot without requiring you to file a motion and without requiring you to post a bond. Okay? So I'll adjourn this 2 weeks. You come back with your bills.
Can we do that?
Do you have your bills?
I can pull it up on my phone.
Yeah, but this is not calling in the last day or two. You were supposed to call here by, but just please listen. You were supposed to call here by July 30. Do you have proof that you called here by July 30 and set up a court date? You said you called 10 times.
Yeah.
Okay, so you go get that proof. I'll put the file right here.
Yeah.
You have a bill. Okay, go check it out. I'd love to see it. Thank you.
We'll see what's going on with that.
You take the break.
What? He's supposed to go in to see.
I know he's supposed to see the prosecutor. I told him that. He was arguing with me out there. You had just said he wanted to leave, so sorry with him. Now he's at Hessen's or are you? I'm gonna go again. I'll hand.
All he needs to do is go into the see the process.
There.
Oh, boy. Okay. Lisa? Can you hear me?
Yes, I can hear you.
You don't need to, don't let them argue with you. If they have something to say, you tell them to come down and see me. This is nonsense. I mean, he shouldn't be treating staff like that or anybody here.
Yeah. I ended up, yeah, okay.
I know. It's
I was
not-
just
I'm
trying to
not-
explain the process, but you know how
I
that goes.
know. He's had multiple misses on those cases and he wants to. We have anything else?
No, nothing right now. I could use a little break.
Okay, let's take a 5-minute recess, everybody. Okay, we're gonna go off the record. You stay seated. We'll be back here momentarily. Ma'am, I'll call your case as soon as I come up, okay?
Mr. Dillon.
Good morning. How are you?
Did you talk to Tony?
Yeah, I did. I was,
Okay.
yeah, on my way in. So
To impeding traffic on that file, right?
yes, Your Honor.
And then the court's going to go ahead and dismiss the prohibited truck route, which is file C, and the court will dismiss file B, dismiss file C, at least as the original charge with a plea to impeding, and then as to file A 540 on the misload. True?
True.
To the charge of misload on behalf of the company, responsible or not responsible?
Responsible.
And on file C to impeding, responsible or not responsible?
Responsible.
All right.
Your Honor,
Just let me accept the pleas first,
Okay, all right.
and I'm going to dismiss the original charge on file C. I'm going to accept the plea to impeding, accept the plea to misload, dismiss the operating without proper endorsement. What, do you need more time?
yeah, Your Honor, we know what we owe and it's a lot, but we did pay a fair amount yesterday and over the years, we have been a very good payor. So I agree with you. I don't want to kick cans down the road just for more time. So if you could just give us maybe 90 days.
90?
That'll help. What's that?
90?
80?
I'm saying, is that what you said? 90? Is that what you're asking
90
for?
days. So that way I accomplish what my client, a little time to fill the coffers.
All right, I'll do that. Pay by, so 540 on the one file and 185 on the impeding, and I'll give them till February 6th of 26, okay?
Awesome. Thank you, Judge. Appreciate
Good
it.
day. You're a pleasure to deal with, Mr. Dillon. Take care. Thank you. Catherine Denise Feisick? 25G306680. What's that?
You said it right.
Did I?
Yeah, no.
Ding, ding, ding. Too bad I wasn't on Jeopardy and that was the final Jeopardy question. Come on, up here. Who's Catherine Denise Feisick? You are?
Yeah.
What's your name?
Catherine Denise Feisman.
And who's this? Your lawyer, your bodyguard? What is she?
Daughter, and at the ticket, I was driving the car.
You don't need to sit here and tell me that. They issued it to the wrong defendant, so they're dismissing the case, right?
Yeah.
Why are you sitting up here and spewing that you were driving? You'd make a lousy criminal, you know that?
Oh, boy.
Prosecutor moves to dismiss. Prosecutor moves to dismiss. Case dismissed, motion of the prosecutor. Take care. Have a good day. Thank you. All right. Sarah Nicole Francis. Soik. 25G306677. A and B. I don't know what he means by this. Your name?
Sarah, what first?
You're going to plead to impeding traffic on file A. And then it says no agreement can be reached on this other one. That's on the obstructed vision. Are you pleading to that too?
He's over there, had an option to either take points and.
No, I get it. I need Robinson in here, John, if you know where he is. I'm just not understanding how he wrote this up. Looks like he's having you plead to impeding on A. And then on B, it says paying this and reducing A file. So it looks to me like he expects you to plead on the obstructed vision. That's 2 points too, though, you know.
That's not what he told me.
Well, let me get him in here. We'll clarify this, okay? Just bear with us.
He's on.
Okay.
Thank
Good morning, Sergeant. How are you? Your name?
Please.
You don't have to raise your right hand.
Say hi, then.
Oh, yeah. So on the A file, you got impeding here and the speeding to be dismissed. And then it looks like you check no agreement can be reached on the B file. That's obstructed vision. Then you said, oh, they're paying this and reducing A file.
Yes, Your Honor. So she was going to pay the obstructed vision, and then we're to drop the impeding traffic, or drop the first one to the impeding traffic.
Right. So, but I want you to understand, she didn't seem to understand this. Obstructed vision's 2 points. Do you understand that?
I
Okay.
just didn't want points. That's why I asked for the hearing.
I can see if we can find like,
What's her record like?
get a couple crashes on there, like 22, 24.
You failed the yield. It's a hazardous action in 22. I mean, you could just do 2 impedings. It's up to you.
Okay. That way there's no points on there. I appreciate it. Yeah, we can do that then.
Can you change this
Yeah.
step form for me, please?
So 0 point. So.
That's okay.
Thank you.
All right. So you're going to plead impeding on file A. They're going to dismiss the speed. True? To the charge of impeding traffic on that, responsible or not responsible? All right. And then on the file B, he says he's going to reduce that to impeding. I just want to take a quick peek there. You're going to plead to impeding on that, right? To that charge, responsible or not responsible? All right, I'll accept those pleas to impeding, dismiss the obstructed vision and the speeding. On the speeding, you're going to pay 155. On the obstructed vision, 125, 280. You can pay that today?
Yes.
Go down the hall and take care of that. You better thank this good young man here.
Thank you.
Have a good day. Daniel Giles. Okay, good enough. Who was it? Do you know, sir? Okay, that's fair. What's that?
Did you talk to the attorney? You talked yet? Well, that's all I know.
Okay, Mr. Gage.
You should. Yeah, he already talked to him, so you should have a file, right?
I do. It's not in here.
Oh.
Is Maxon in here? Did you have a lawyer?
They all spoke to Gabe. I don't know. I got.
Okay.
They judge each other. All right. He's calling cases right now. Okay. You said 1 minute, yeah.
Okay. Is there a conditions of bond sheet?
Yep.
Thank you.
I've been trying to hand you for 2 days. I'm glad you finally need this. Every time you ask for a form, I'm like, you want this? You want this one? No. That's fine. The only one that was close to me, so I was like, he must use his son the other day.
Give me 1 second, Mr. Gaith.
Sure.
Against Daniel Curtis Giles, 25T 646-053, A and B.
Good morning, Judge. Matthew Gates, here on behalf of Mr. Giles.
Sir, again, you can have a seat there if you'd like. Whatever, you want to have a seat? Pardon?
Daniel Giles?
I just want to make sure. Do you want to have a seat?
Okay.
All right. Lisa, I'm just going to end on the order here, A and B files, There's two different counts. I just want to make sure they. Two charges of assault and battery. How does he wish to proceed?
We'll stand mute and wait reading, Judge.
All right, I'm entering a not guilty plea. Anything you'd like to say regarding bond?
Judge, we'd ask for a personal bond. Obviously, Mr. Giles is here to take care of this matter, and he doesn't have a significant criminal record. And we'd ask for a
How does that be? Not a significant criminal record. He has a criminal record, just not significant.
Well, I misspoke. I don't believe he has a criminal record whatsoever.
I'm just kidding. I'm just kidding. All right, listen to me very carefully. I'm going to give you $1,000 bond, personal bond. You cannot leave the state without the consent of the court. You cannot violate a law. You're not to have any contact with Nicholas Cady and or Benjamin Forrest. You cannot write, phone, see, text, email, or communicate with them or have anybody else do any of those things for you or on your behalf. No phoning, no seeing, no communication of any kind. No contact with prosecution witnesses except through your lawyer. You're not to possess firearms. No firearms. No dangerous weapons. You're required to go over to the Trenton Police Department to be fingerprinted and photographed by 1 p.m. today, and you're not to go near Corwell Hospital. Do you understand that? All right, good enough. So we'll give you a new pretrial date. You're going to have to fill out a petition for a court-appointed lawyer going forward. Where do you work at? When did you last work?
I haven't worked since October 1st.
Where were you working before October 1st?
Station.
What happened on October 1st? Okay, wait a minute, wait. Let me just, oh yeah, that was the incident date. Okay. Don't answer any more questions. Lisa, give me a new pretrial. Are we going to do the 20th?
November 20th at 9:45.
At 9:45. We're going to give you a copy of the bond sheet. You're going to have to fill out a petition for a court-appointed lawyer. We're going to give you a copy of the order for print. You have to go over to Trenton to get fingerprinted and photographed by 1 p.m. today. So you're going to go down the hall, get your notice, get those documents, and then come back on the 20th and go to Trenton today for prints. Good luck. Aiden Page Maxon, 25T6464444, A and B.
Good morning, Judge. Matthew Gates, here on behalf of Anticipated member record.
Even Page Maxon.
All right, Ms. Maxon, Mr. What are we doing here? Does she have insurance now, I hope?
She doesn't, Judge. I was able, for arraignment purposes, Judge, will stand mute. For pretrial purposes, Judge, I was able to talk to the city attorney. I believe he's amended the no registration misdemeanor to the civil infraction.
Yeah, it's driving an unregistered vehicle to no proof of registration. That's okay. No proof of registration is the civil infraction, and then he's going to dismiss the no insurance too, right?
Yes, they did provide proof of both, Judge.
All right, ma'am, do you understand everything?
Yes.
You want to plead to the civil infraction and no proof of registration?
Yes.
All right. To that charge, responsible or not responsible? All right, $135. You go down the hall and pay that. I'm dismissing the driving an unregistered vehicle and the no proof of insurance. Anything else?
She has 7 days to make that.
Where do you work at?
I work at Dollar this way.
Downriver Spring?
Yes.
What do they do? Make springs?
It's complete auto care.
You come back here by the 20th. I'll give you till the 20th to pay, okay?
Thank you.
Good luck. Have a good day. If you need more time, come talk to me, okay? Justin John Courtney, 25G81173.
Judge, I can get on behalf of Mr. Porter.
These are easy, huh? You had a rental inspection and everything's good. Your name, sir?
Good morning, Justin Porter.
So the prosecutor moves to dismiss. He had the rental inspection?
He did have the compliance history.
Good. Case dismissed. Their motion. See how easy this is? Good luck. Hayes, Nathaniel David Hayes, 25T643636.
Good morning, Judge. Matt and Gabe, on behalf of Mr. Hayes. Mr. Hayes, take the full name for the record. Nathaniel Hayes.
All right, so your client pled guilty to illegal transportation of a firearm. Plea the prosecutor offered was for him to take that under 771, or the court to take it under 771. And I ordered a pre-sentence report. Have you had a chance to review the report with him? And are there any material additions, corrections, or deletions?
We have had a chance to review for the correction issue.
Anything you'd like to say on his behalf?
Just to, he is 32 years old. He is steadily employed. He's been employed for 3 years with a company called Pool Guys. He averages about $1,200 a week. He is engaged to be married. He does.
Congratulations.
He does have 2 children, one from a previous relationship. And then his fiance also has a child from a previous relationship who lived with them. Judge, he does not have a significant criminal history, other than this current charge, Judge. He doesn't have any other convictions. We'd ask the court to adopt the recommendation. However, Judge, we do want to point out with regard to recommendation number 6, the requirement that he receive a GED or a high school diploma.
He doesn't want to do that?
He does not, because he works full-time, Judge.
How many hours you work?
At most 60 hours a week. And then I have 2 kids I gotta take care of. And the time I have to spend with the old lady, I got.
What do you mean your lady? You know, I don't know what you mean by that.
His two three wife.
Oh,
Sorry.
I knew what you meant.
He's too young to say.
Yeah, that's something they used back in the 60s. Huh? When I was a kid.
I was raised by
You were raised by what?
I was raised by my grandparents.
Okay, well, that explains it. All right, what else?
Judge, with regard to item 7.
Why don't you want to, you need to get this for yourself. I'm not going to order you to do it. Listen to me. I'm not going to order you to do it, but things are going to come up in life and you want to be able to be in the best position to make the most money and to have a job that you really like. You really like what you do?
Yes, sir. And I might add, before this 3-4 years I've been working with Pool Guys, I was a chef for about 8 years.
Where?
At Little Caesars and other establishments.
And
Mid 29, which is a 4-star restaurant, year 1.
Maybe you can do both? I'm just kidding. Go ahead. What else? Anything else? I won't order that.
Item number 7, Judge, with regard to the possession of firearms. He did ask me, now that was just during the period of probation, correct, Judge?
Yeah, not forever. Yeah. Anything else?
Nothing else, Judge. We asked the court to adopt the recommendation.
You know you can't do what you did, right?
Absolutely. I like my lesson.
Why were you doing it though? If you knew,
I didn't understand at the time that I was doing anything wrong. I thought as long as it was locked up in a way not easily accessible that I was following the law.
6 months probation, you cannot leave the state without the consent of the court or violate a law. Change your address, place of employment, or home telephone number. You must notify probation. You have to report as directed. Complete 1 day on the court work program. There's a $35 charge for that. Complete 1 day or 8 hours of community service by December 20th. Attend and complete the firearm safety course. No firearms, no dangerous weapons during the period of probation. You're not to be in possession of any one of those. $100 fines, 50 costs, 75 victim's rights fee, $50 justice assessment. So fines and costs are $275. Probation fees are $120 for $395. Screening fee is $60 for $455. Attorney fees are $40 for $495. You pay that, you do the other things, stay out of trouble. and at the end of 6 months, you come back, I'm gonna give you a review hearing date, I'll be happy to dismiss your case. If you violate, your probation could be revoked, you could be incarcerated for 90 days. Do you understand that?
Yes, sir.
All right.
Does the court consider early?
I mean, I don't have a problem. It's up to the prosecutor to move to dismiss it though, once taken under 771. I'm not gonna do that on my own.
Yes, sir.
Okay? So, what do you want here? Let's see. Do you have all this to pay or do you need? I'm sorry. Go ahead, Lisa.
Sorry, I thought you were asking me for a date.
That's
April
okay.
23rd of 26 at 9:00.
April 23rd at 9 o'clock of 2026. Do you have all this to pay?
He does not, Judge.
How much does he
I'm
have?
right this second. I have about 150. I can pay today. I can pay it tomorrow, actually.
I'll just let you do this. 150 now. Do you get paid weekly?
Yes.
50 a week. 50 a week, and I'm gonna start this beginning on November 10th, okay? If you ever need more money, or more time rather, we don't know. No, I just got done. I get it. 50 a week starting November the 10th. If you don't have the money at any point on any one of those due dates, call the court. We'll go on Zoom. I'll be glad to give you an extension. Just don't ignore me. You have to either come in here on or before the due date, call the court on or before the due date at 8:30 and we'll go on Zoom, whatever's easier, okay? Best of luck. Thank you. Dylan James Hall, 25B148235, A and B.
Good morning, Judge. Megan Gates, here on behalf of Mr. Hall.
Mr. Hall, your name?
Bill J. Cole.
So he entered a not guilty plea on these. The charge is failure to provide proof of completing community service by September 15th. He's got one case, the drug charge was taken under 7411. He's got a concealed weapons charge as well that was taken under item. So if he pleads guilty or if he's found guilty, his probation could be revoked, HIDA status revoked, 7411 status revoked, conviction entered on those, and he'd be subject to up to a 5-day jail term. So what is he going to do?
Judge, I've spoken to Mr. Hall. With regard to the
Call in Jessica.
Community service, he's got 3 hours left. So as far as today's hearing proceedings, he is going to plead guilty to the violations.
Is that right?
Yes, sir.
You understand everything I said?
Yes, sir.
You understand all your rights?
Yes, sir.
If you plead guilty, you're going to give up all those rights, and we're not going to have a hearing. Do you understand that?
Yes.
All right, to the charge that you failed to provide proof of completing 8 hours of community service by September 15th of 25. How do you plead? Did you fail to provide, and I'm going to ask you this once. It's on both counts. So you understand you're pleading guilty on both counts, correct?
Yes, sir.
And did you fail to provide proof of completing your 8 hours of community service by September 15th?
Yes, sir.
Anybody force you to plead guilty?
No, sir.
Plea is accepted on those. Why didn't he have it done? Come on, I didn't order that much.
Judge, he works full-time and.
Well, what's full-time? 40 hours?
I'm sorry?
What's full-time? 40 hours?
So usually 40 hours a week.
Sometimes less?
Sometimes more, sometimes less.
I love this generation. They consider full-time 18 hours a week. Your name? All right. What do you have to say? Go ahead.
You're talking.
Yeah, I'm talking.
Additionally, he did say he made an effort to find some places that he could actually, where he could do these hours. He wasn't able to, and then I believe his parents were the ones that went in actually physically to the Salvation Army.
Why are your parents doing your work? How old are you?
Huh?
How old are you?
19.
And they actually brought him a volunteer form where he filled out, he was actually finishing those hours. He did assure me that he's got 3 hours left and those will be done by the end of.
He graduated, right?
What?
Did you graduate?
Yeah. Graduated this year.
All right. From where?
Berkeley.
He's got all.
You live with your parents?
Yeah.
Smart. Rent's free, right?
Okay.
Rent is free?
Yes, sir.
Nice, nice. I keep threatening to go back and live with my mother. All right, what do you have, Jessica? What do you have for?
Client,
All right.
up to date on his payment plan. I've sent him for on-demand testing. He's been negative. He completed his 1-day report work program. He does have the substances of abuse class with class A. He did do the initial intake. He's just waiting to get sketchy.
Yeah, I'll go.
You seem like a nice kid. You gotta follow through on this better, okay?
It keeps slipping by me, I'm sorry.
You're gonna to serve I'm gonna go light on you, okay? To serve 2 additional hours of community service plus the 8 for a total of 10. And I'm gonna give you by, December 1. I don't know why I'm being so nice, but that's what I'll do.
Judge, he's already completed 5 of the
I know,
originally ordered 8. He's
right,
got 3 left.
right.
So plus the 2 would be 5.
Oh, I'm sorry. I thought you said that he, well, no, he's only gonna have to complete 10 hours. We're not gonna count the 5. I mean, I'm gonna count the 5. So
You're
he's
gonna
got 5 done.
Okay,
So he's gotta do 5 more.
I apologize, my misunderstanding.
That's all right. I didn't make it very clear. All right, serve total of 10 hours, community service. 2 additional by December 1. All right, I know I wasn't hurting. All right, but you're 19. So I'm gonna cut you a break. You seem like a nice kid. But be more attentive with this, okay? Good luck to you. I wish you well. Thank you. No cost. Thanks. What did I do here? Rogers. Robin Lynn Rogers, 25D 646-054. And then we can bring in Officer Cerna, Lisa, or the defendant on Cerna, right? Your name? All right, what happened here? They're gonna move to dismiss? You don't own the dog?
No, sir.
Did you have a lawyer?
I did.
Who was your lawyer? Don't worry about it. I'm gonna enter an act guilty plea for you. If you want to wait for him, you can. I can just, they're moving to dismiss. I can just nolly process. Nah. All right? Unless you want your lawyer stand. You sure? All right. Case dismissed, motion to the prosecutor. Says you didn't own the dog. I don't know how they write somebody who doesn't own the dog. Right. Timololu. I'm sorry. Timololu.
Yeah, Timmy Lulua is correct.
Right.
Yes, that is right. I'm going to turn my camera on. There you go. My apologies. There you go.
You're fine. What are you apologizing for? Huh? You got on a lot quicker than 98% of them. What's your name, sir?
Well, it's Timmy Lulua, right? But I go by Timmy, right?
You changed your name?
No, it's just
I got it. I'm just messing with you. The officer didn't show up. You're a winner. Case dismissed. Okay.
Well, thank you, sir.
Good luck
thank you,
to
sir.
you. Have a great day.
I appreciate it. Thank you, sir.
Thank you. Do I have any other files down there, Jennifer?
No, sir.
What's going on with Mr. Thornton? Do you know?
There's both talk to the Trent prosecutor.
Is my Trenton date, it's my Trenton day today, right, Lisa? Or is, let me see.
It is.
You asked for a lawyer, right? Hey, Tony, can you come in here, please? Thank you.
Okay.
Listen, did you talk to Mr. on the case in front of Judge Hessen?
I know.
Where's he at?
That's the individual that was arguing with everyone.
I know.
He was advised to go out in the hall and talk to the Trent prosecutor, but he decided to go argue with Lisa and next.
Where's he at now? Do you know?
Person is this? Mr. Ford.
Lamar Thornton.
Gentleman,
Oh, he's in my room right now. The gentleman?
Yes. So,
I'm presently in my room.
no, it's okay. Well, so when you're done pre-trying that, send him in here. Okay, so that's Judge Hessen's case. So that's gonna go in front of her, but I got 2 others. I got a show cause and a probation violation, okay?
Understood. I'll
Thank
take
you.
care of that one. So that case is going to Judge Hessen?
The one you have in there, yes.
Thank you. Bye.
I'm sorry, sir, you asked for a lawyer, right?
No, he's very much that David Brown.
Okay, I thought you were in front of me already.
Not today.
Okay. Morning, Mr. Crawford.
Morning, brother. How are you?
Not bad.
Good. Good.
Okay. I get rid of that one case series.
Dismiss it.
Yeah, I just went ahead so she didn't have to wait around.
Sure.
People against Markham. This is people against Christopher Michael Markham, 25T 646696 A and B and C. Good morning.
Good morning, Your Honor. Michael Crawford, representing Mr. Marco. Sir, state your name and your rating.
My name is Christopher Marco.
So what are we doing on this one?
Well, for the purpose of arraignment, my client likes to stand in the way of formal reading of the charges and state personal bond. There has been an offer from the people, Your Honor, my client would like to avail himself of, whereby count A would be dismissed outright, count B would be reduced to failure to properly affix the plate, and he would be responsible for that charge, and he would be responsible for count C.
Okay, he didn't write up the other one. That's what the agreement was. He didn't say anything about the detective equipment on here, but that's what the agreement is?
Yes.
All right. Is that what you want to do, sir?
Yes, sir.
Both of those are civil infractions, so I'll dismiss file A once, that's no valid ops. Once you plead to failure to properly attach the plate, that's a civil infraction. And then you also plead to defective equipment, and I'm going to go ahead and dismiss the no ops and the improper plate. Do you understand that?
Yes, sir.
All right. All right, to the charge, failure to properly attach the plate. How do you plead? Responsible or not responsible?
Responsible.
Defective equipment. How do you plead to that? Responsible or not responsible?
Responsible.
All right, pleas are accepted. The no ops is dismissed. The improper plate's dismissed. And I'm going to accept the plea to failure to properly attach the plate and defective equipment. On the defective equipment, I'm going to charge you $120. And on the improper attachment, $135. $255 is your total. Can you pay all that?
Your Honor, my client can pay all that today. We have a payment order to propose. You can pay $100 today. We just started work, unfortunately, and then you can pay $100 every 2 weeks starting November the 21st to the balance.
So you pay $100 today on the failure to properly attach the plate. And then by November the 21st, you pay the rest of that. Okay? And then I'd just suggest that you pay more, and I'm going to give you until December 5th to pay on the defective equipment. Okay?
Yes, sir.
Do you understand all that?
Yes, sir.
Okay. Good luck to you. Wish you well. Thank you.
Thank you, Ron.
Donald Henry Dubry, 25G 81175A and B and C. Mr. Dubry, how you doing?
Good. How are you?
You did it? They're going to dismiss this?
Yes, sir.
Wow. Somebody did what I asked him to do for a change. All right, good. All right, so let me just check something out here real quick. So it says property maintenance 3. They're going to move to dismiss all these. Cases are dismissed, sir. I wish you well. Good luck to you. Thank you very much.
Thank you.
Have a good day.
Yes, and you too, sir.
Thank you. Come on up, Mr. Thornton. Recalling Robert Lewis Thornton Jr., 25T 644-914B and 25W837-260. Your name? All right, so I'm gonna go ahead. You have a probation violation here of failure to pay your fines and costs as ordered, 470, and failure to clear all your warrants by August 25th. And then you have, on the other case in front of me, you have a failure to pay 260. So actually, it's Judge Hudson's, but I'll just go ahead and handle that. You still wish to proceed without a lawyer?
No, I was able to elaborate. I want a lawyer to sign.
Pardon?
No, I want a lawyer.
Okay, no problem. We'll give you a lawyer. Go out in the hallway, get him a lawyer, John, and then you'll come back in front of me, okay?
Sorry about that.
Let's see. Where's my rubber bands here? And you're here on a traffic ticket, sir? Set an informal hearing?
10 o'clock.
10 o'clock in the office,
Waiting on the office.
All right, so we'll be back out in 7 minutes or so. Stay seated.
It's,
Yeah, it's hard.
across the street. Like, oh, this really- yeah.
You're gonna pay too much for it.
I think we're like about some- We're still involved.
All right, guys, the people versus Cyrano Johnson.
Overwater Assistant Prosecuting Attorney for the people.
Good morning, Your Honor. Veronica Glenn.
Go ahead.
Should I request permission?
What?
Should I request permission again?
Didn't I already give you permission?
You did.
Did I? You know, you are too young to be forgetting things.
Oh, my God. Okay.
That's not you, Gary.
I forgot.
I've granted permission.
Thank you. Your Honor, I'm asking for an adjournment on behalf of my client, Mr. Johnson.
You have a green sheet or you gonna?
I do have a green sheet.
I will adjourn the probable cause hearing in this matter to December 4th, 2025, 9 a.m.
Thank you, Your Honor.
Thank you.
Bond will continue. Mr. Johnson, how's it going?
So far, so good.
Huh?
Thanksgiving.
What you say?
Good. So far, so good. Waiting on Thanksgiving. I do turkeys. So.
Oh, you do
December
turkeys?
4th. Yeah, that's good. So you won't interfere with none of that.
What, at the church you do?
I fry them. Yeah.
You fry them?
Fry turkeys for people.
I have to go find Mr. Johnson. All right.
Hit me up.
All right.
All right. Thank you.
You take care. Court does call the case, People versus Randolph Taylor.
Okay, you know, sorry, journey. Study the journey. We study.
Oh, okay.
What is really going on?
Miss Cannon.
I will tell you, Your Honor, at this time, I am going to ask for an adjournment of this matter. Late yesterday, we did get an offer and had already visited with my client. I want to convey that to him. He wants a 1-week adjournment to consider though, because he was ready to go to exam is where the issue is coming in at. And I do have.
Sir, can you state your name? Randolph Taylor. Thank you.
Oh, sorry.
No, it's okay. You just started talking.
I did.
You don't even let everything, you just start talking. I don't even know what you're talking about.
Yeah.
Shall he come and tell me you told this week?
I'll give him the 1 week adjournment under those circumstances.
You tell me they come and tell me.
Yes. Sorry, I didn't sign it, Your Honor. I'm sorry.
Oh, so it's half filled out.
It was 2/3.
No. I don't even know what this says.
It says, you
No.
are awesome. So,
Probable cause conference will be adjourned 1 week out to the 13th,
Thank you, Your Honor.
2025, 9 a.m. Bond continued. Thank you, sir. Court calls the case of the people versus Jermaine Johnson.
Trevor Maysville for the people.
Assistant Public Defender Sandra White on behalf and not with Jermaine Johnson. I have spoken to him this morning. He said
Did you?
yes, several times.
How was he doing?
I was out there one time when you called my case.
So he was here?
No, I was on the phone. He's not doing too well. He said he's homesick and he was trying to get a ride.
Yes,
So
it has a bond violation.
yes, I did make him aware of that. So we are asking for an adjournment. I did do a green sheet.
That's okay. I don't need it. Bench warrant will issue for defendant's failure to appear. Bond is setting amount of $25,000 cash surety. That warrant will issue immediately. But
Why so high, Your Honor?
you want me to give me 50?
No, I'm good.
Okay, all right. Thank you.
Why so high? You know,
I don't remember what happened to the last attorney that asked me that. Haven't seen him since. Court calls the case, people versus Andrew Travis.
Another one is prosecuting attorney for the people.
No, we'll wait.
Public Defender, the prosecutor.
Yeah, he already did that like ages ago, waiting for you.
Sergeant Carey, I can rule Your Honor on behalf of Mr. Andrew Travis. Mr. Travis, state your name for the record, please.
Andrew Jacob Travis,
Thank
Your
you,
Honor.
sir. I have before me a plea form that indicates that the defendant will be pleading guilty to an added count 2 of attempted resisting and obstructing the 1-year offense upon a successful plea. That charge count 1 would be dismissed. That's the court's full understanding of it.
Yes, Your Honor, that is what we have, Judge.
May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do. Andrew Jacob Travis.
All right. Sir, it is this court's understanding you're going to plead guilty to the charge of attempted resisting and obstructing a police officer. That is a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court cost. Do you understand that?
Yes, I do, Your Honor.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Barr in 1418 District Court. You understand that?
Understood.
So wish to plead guilty?
Yes, I do.
And to that charge, how do you plead?
I plead guilty, Your
Now,
Honor.
you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, I understand.
All right. You signed an advice of rights form. Is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No, but I do have matters in Wayne County right now. But I'll be honest, Your Honor, I'm kind of fear for my safety in Wayne County. I just wanted to put that on the record, so I don't know if anything could change where I do more time in Washtenaw. Just wanted to put that on the record.
Huh? Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Has anybody threatened you or coerced you in any way?
No,
You're doing this voluntarily?
of my own free will.
Okay, involuntarily? Yes?
Yes, voluntarily.
Because you believe also that you're guilty of this offense?
Yes.
on the date of October 2nd, 2025, at the location of 128 North Normal Street, City of Ypsilanti, Washtenaw County, State of Michigan. Did you come into contact with officers from the Ypsilanti Police Department?
Yes, I did.
What happened?
I resisted their arrest when they tried to detain me.
Okay, they were trying to arrest you?
Yes.
All right, and so they were performing their duties.
Yes.
And in what way did you resist them?
In what ways I wouldn't put my hands behind my back when they gave me a lawful order.
Okay, so they were telling you to do something and you just wouldn't do it.
Correct.
All right. It didn't work out well, I bet.
No.
Okay. Sir, if I accept your plea in this case, between the time of your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, the court would no longer be required to follow any sentence evaluation or recommendation in this case, and you would not be entitled to withdraw your plea. You understand that?
Understood, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
Neither is defense, Judge.
Have I complied with the court?
Defense is satisfied as well, Your Honor.
All right, court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 1482 probation. Sentencing in this matter will be
December 10th at 10 a.m.
December 10th, 2025, 10 a.m. before Judge Barr.
All right. Thank you, Your Honor.
Thank you. Bond will continue. Thank you, sir. Good luck to you.
Thank you so much, Judge.
Have a good one.
Court does call the case of the People versus Sandra Law.
Stephanie Cannon on behalf of Ms. Law. Ms. Law, could you please state your name for the record?
Sandra Law.
Miss Glenn.
I lost her. I lost my intern, Your Honor. I'm sorry.
All right, what are we doing on Ms. Law's case?
Well, Your Honor, we are working on the case. She does have a bond violation. The court is well aware of it. We did receive, and I did provide the prosecutor.
Counsel approach.
Yeah, here I come. Be right back. Your Honor.
What I'm going to do is, we've had a bench conference in this case. I'm going to adjourn this out 1 week to November 13th, 2025 at 9 a.m. However, on September 25th, she tested positive for cocaine or other drugs, but my understanding is that medication. That's on September 25th. October 1st, she then tests positive for alcohol. So I have those 2 consecutive tests, or those 2 tests where she's got something in her system she's not supposed to have. And then I don't have another test from her.
Yes, Your Honor. I do understand that, and I will be providing the court with some medical records indicating that for a very good chunk of this, she was actually hospitalized. But my view of it, in truth and candor, is not indicated for all of it, but for a very good chunk of it, she was hospitalized. And Your Honor, I will do an order for inpatient treatment to see if that'll work for this court.
It may, but at this time, given what I'm seeing, I just put it over 1 week. You can get that information to me, but this time defendant's bond is revoked and it's remanded.
Thank you, Your Honor.
Recall is ready on. That's your own.
Recalls case of the people versus Suzette Hampton.
Cash calls for the people.
Assistant Public Defender, should I be here approval, Your Honor, on behalf of Suzette Hampton. Stand state your name for the record, please.
Suzette Hampton.
I knew you would show up. Everybody else had little faith in you. I said, Miss Hampton's gonna be here. I'll pass this matter.
I couldn't hold it any longer. I'm sorry.
What'd you say?
I couldn't hold it any longer. I'm
No, it's
sorry.
okay. It's okay. I knew you were here. I knew you'd come back. That's right.
Yes.
Everybody else didn't know. Everybody else thought you took off.
Oh, no.
But no, I had faith. All right.
Judge, did I get the?
Okay, that's not how that really. But anyway,
We'd like an adjournment. Does the court
were you looking
have-
for your green sheet?
I was.
I already have it.
I thought
They
so.
called the
I
case.
knew
and You
it.
gave it to us.
I did. Okay.
And
yeah.
it was shocking for you. How much time do you were looking for?
Judge, if we could get like a month, I mean, we're working on mitigation.
You're asking for a lot today.
I need to go to India.
December 4th,
When are you going to India?
2025, 90.
Thank you, Your Honor.
Bond will continue. All right. Thank you, Miss Hampton.
Okay. Thank you so much, Your Honor.
You're welcome. Court calls the case, people versus Thomas Basher.
Cash calls for the people.
Morning, Your Honor. Mike Getty, Assistant Public Defender on behalf of Mr. Vasher, who's here to my right. State your name, Mr. Vasher.
Thomas Basher. All right. Thank you. Yes, sir. Question and adjournment.
Yes, Your Honor. And we are requesting a release of treatment. I did submit an order to that.
And if you submitted it, I would have signed it. Mr. Basher needs to get himself in. So I don't have a problem with that.
Thank you, Your Honor.
And you said there was a global resolution.
Yeah,
The other cases, how much time do you think you'll need to try to wrap up?
maybe 3 weeks, Judge.
3 weeks. I'll give you the 25th or December 4th. Which would you prefer? It's like 2.5 weeks and
December 4th.
December 4th. Okay. Probable cause conference, December 4th, 2025, without objection. 9 a.m. Bond will continue. All right. Thank you, Mr. Basher. I don't, Mr. Getty, I don't,
I can resend it if you like, Judge.
well, hold on. No, I did sign an order modifying, but I did.
Oh, thank you, Judge.
You're all set. Court calls the case, people versus John Logan.
Cash calls for the people.
Sir, please state your name.
Sean Logan.
Your Honor,
Yeah.
may I approach with the prosecutor?
Well, what are we doing?
Well, he's waiving exam, but he also has a bond violation.
Yes, he does.
And he has a medical card that I wanted to share with the court also. And I wanted to share some other things with the court that I didn't really want to put on the record.
Trying to hear everyone at the same time.
You understand that a preliminary examination is a proceeding by which the people would have to show by the standard of probable cause that the offense alleged was committed and that you committed it.
Yes.
You understand that waiving that, you will not have that hearing and that you'll proceed to circuit court for further resolution.
Correct.
People also waive their right?
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on a single count.
Your Honor, we acknowledge receipt of the information, waive its formal reading and ask this matter to be set for a pretrial.
Defendant having waived formal reading, standing mute to the charge, court will enter a not guilty plea. Pretrial will be set for
November 17th at 1:30.
November 17th, 2025, 1:30 before Judge Hamud.
the truth.
I understand. We'll talk with you about it. Thank you.
Bond will continue.
November 17th, Your Honor. Yes.
Yes.
Thank you, Your Honor.
Court calls case People versus Jack Saunders.
I should call this for the people.
Jack Sanders. I know you would have been right up here, but Akin really was talking in your ear, wasn't she?
Hello, Judge. Ronica Glenn, appearing on behalf of Mr. Saunders. He is not present today.
He's not present.
No, so we are asking for an adjournment or at a minimum a show cause.
Really? Did she tell you to ask for a show cause?
Yes.
Who did? Cannon said to ask him for a show cause?
She sure did.
So she was trying to set you up. That's okay. I got your back. Bench warrant will issue for defendant's failure to appear. Bond is set the amount of $10,000 cash surety. That warrant will issue immediately.
Okay.
She did not hesitate not to protect Cannon. She sure did. Just set me right up.
Thank you, Judge.
What? Yeah. Court calls the case. People versus Procopio Vitale.
Trevor Maple. Mike Gandy, Assistant Public Defender, on behalf of Mr. Vitale, who's approached.
Your name, sir? Procopio Vitale. You're seeking an adjournment.
Yes, Your Honor. Mr. Vitale has been on the list to be assessed for Judge Kunke's sobriety court. I've been in touch with them. They're still, they're working through people. I don't know. They weren't particularly clear about how long I might seek, but I'd ask the court to maybe set it for 2 weeks out. I know he's been on the list for a long time. I did speak with them last week.
I remember a certain point. Okay.
Yeah.
Well, let's do this then. I've got 2.5 weeks. Let's go out to that and see exactly. Maybe we can get a handle on where we are. So it'll be November 25th, 2025, 9 a.m. All right. His bond will continue.
Thank you, Your Honor.
Hopefully they'll get to him. Has he even had has he had the beginning part of that?
I'm sorry?
Has he had the beginning part or?
I don't think they've been out to see him yet. Your Honor, if I will check with them, would the court consider a release to treatment if that would be a quicker route for him to get treatment?
Yeah, if you submit that order, certainly. I know that he's been waiting. It's like,
okay.
I've been seeing him so much, I was going to invite him to Thanksgiving. So, yeah, I mean, I don't have a problem releasing him.
Okay. I'll check and see which one will get him assessed first and
see if we can do it that way.
Thank you.
Thank you. Good luck. Christine, got it.
I'm sorry.
Oh, correct. Court does call the case of the People versus Matthew Wallace.
We just gotta get you.
Really?
Trevor Maple for the People.
Assistant Public Defender, on behalf of Mr. Matthew Wallace.
Beat him up here, Judge. I got up here first.
No, it's pretty much like a blind squirrel finding a nut. It's gonna happen eventually.
Call it progress.
Faster than the broken clock.
Yeah, exactly.
You're right. You're right. Thank you, Judge. State your name for the record.
Matthew Wallace. Thank you. You're asking for an adjournment.
We are, Your Honor. We do, the people did make an offer to us. We've we've relayed the offer to my client. So a short adjournment, Judge. We just need to get the paperwork over to the court.
You think a week and you'll.
I think a week
get
would
through
be
to him
fine.
and go?
Absolutely, Your Honor.
Then I'll adjourn these out 1 week to the 13th, 2025, 9 a.m.
Thank you, Your Honor.
Bond continued. Thank you. And we'll take Watkins whenever you're ready. They don't have it.
Nope. He got picked up yesterday by somebody else. So you're good.
Oh, they lost a person? No, I'm kidding. Court does call the case of the Bureau State of Michigan versus Robert Dwayne Watkins.
Trevor Mitchell for the people.
Where is she? Come, geez, oh, Pete. No, you're getting like back and ruling.
I'm learning bad skills. Can my dad on behalf of Mr. Watkins?
Okay. No, they don't have him. He's been
Taken
someplace else. So I don't know where he's.
I believe it should be Adrian that took him. I believe that's.
Are they going to house him in Adrian then?
He has to get arraigned on a felony there.
Okay, so they might hold him there rather than bring him back. We just don't know at this point.
Yeah.
This was, if it makes a difference to the court or defense, this was projected to be a misdemeanor plea.
Got it.
So if we could have just a little bit of time, I can sort out where to do the writ, and maybe we can be ready to go.
Yes, you're on.
We'll give it a shot for the 25th,
Thank you, Your Honor.
November 25th, 2025, 9 a.m.
Thank you. Thank you, APM.
His bond in this matter will continue. All right, thank you. Okay, folks, we would be beginning our 12:30 block right about now. We're gonna start just a little bit late, like probably 15, 20 minutes. I've got to give my staff a break. We thought we would have a break, but I'll give them a break because they were working while everything was down. So I want them to have some bit of respite. All right. So why don't we look at starting about 10-2 with the next block. All right, court's in recess.
All right.
For the 25th or 20th?
I already did my order, but I can do another one. You want free? Alan,
Mr. Riddell, would you mind unmuting and speaking so that we can see if we can hear you?
So like, are you going to?
Good morning, Your Honor, or good afternoon now, Your Honor. James 5490, appearing on behalf of Mr. Wilson, who's present via Zoom. Please start your camera, unmute, and state your name for the record, Mr. Wilson.
Hello?
Mr.
Okay, great. State your name, sir. Anthony Wilson. All right. What are we doing in this case? I don't understand this.
Your Honor, if I could provide some clarity, there was a miscommunication between Mr. Wilson and I regarding my representation in this matter. And the miscommunication between myself and the courts came because this is a 14B matter that was transferred to your docket. So I do apologize for the inconvenience, but
14B matter that was transferred to my docket. No, this starts on my docket.
Well, when I looked on this iChat, or excuse me, for the ROA, it was under 14B, not 14A1. Nevertheless, I think that's where the miscommunication came for the representation, and Mr. Wilson would like to proceed with the court-appointed counsel.
What? Well, it doesn't make any sense to me, counsel. I mean, I got a first thing that we received was, I think, an appearance, and then we get a stipulation. And then I think an email from you asking us to make sure that it gets to me to sign the stipulation. I signed the stipulation. And then next thing I know, I'm getting a order to withdraw as counsel and then a motion to withdraw as counsel on a stipulation. I signed a substitution I just signed that day. And counsel, the representation made has nothing to do with another court or anything else along those lines, but that there's been some breakdown in communication between yourself and the defendant.
What I'm saying is, prior to you signing the order, I reached out to 14A1, who told me that I was able to email to prevent the substitution being signed. I was unaware that the substitution had been signed already, but then when I called 14B, they said it had been signed. So that's where the miscommunication regarding the signatures and the substitution came, but the actual breakdowns between my client and I, for clarification.
Mr. Wilson? Yeah. Were you apprised of all of this?
Yeah, all of this is just too much for me as it is, because I never even been in Washtenaw County or whatever these locations are that's going on with this case. This matter is going on because I have a common name and I've been misidentified, as I've been explaining to everyone. And just trying to get this over with, honestly.
Yeah,
So
but who, Mr. Wilson, I'm not asking you about the incident itself. I'm just trying to figure out in terms of representation. Did you retain this attorney to represent you?
I'm going with the court-appointed lawyer, sir.
Pardon?
We had spoken. I was going to use them, but I can't at the moment. I'm going to go to the public defender.
Is this your case, Mr. Bowling?
It is, Judge. Yeah, Brian Bowling on behalf of Mr. Wilson, Your Honor. I was appointed to represent Mr. Wilson for today's hearing. And then upon receiving the assignment, I had learned that he had apparently had retained counsel, but that seems like that might not be the case. If he wants to go with the public defender's office, that's wonderful as far as I'm concerned, Your Honor. But once I learned that Mr. Wilson had retained counsel, I didn't have any further discussions about the case with him.
Right.
So,
I mean, everything stopped for you.
yes. So I would just, if he is going to proceed with
The defendant dropped. I got to have him back before I do anything. I'm going to pass the matter. Mr. Murray, this is not the way, not only in this county to practice, it is not the way to practice anywhere in this state to do this. This is craziness to me.
Understood.
I'll pass the matter. He's got to sign back on. Court calls the case, People versus Brandon Sims.
Ron Brown appearing on behalf of Mr. Sims.
Your Honor, please introduce yourself.
Brandon Sims.
Thank you.
Did you get the green sheet?
I did.
We're requesting adjournment.
Probable cause conference will be adjourned November 25th, 2025, 9 a.m.
Thank you.
Tuesday.
Thank you, Bond. Continue.
Thank you. Bond continue. Court calls the case, People versus Tina McGarrah.
Assistant prosecuting attorney for.
Assistant Public Defender Sandra White on behalf of Tina McGarrah, who's approaching the podium.
Hello, what's your name?
Tina McGarrah.
Thank you.
Hi, Ms. McGarrah was to make a payment today. She does have the funds. She was on her way up to the counter and I told her to wait because I knew her case was going to be called. So she does have the funds that she was supposed to pay today. And then I believe she's to go further with an offer.
Once the payment's made and receive the receipt, then prepare a form, we can resolve it.
All right, she's gonna do that today.
Yes.
And everything. So let me put this out, and then you gotta get the paperwork. I'm gonna put it out to November 20th, 2025, 9 a.m. On continue.
Okay, you want the green form or? Thank you, Your Honor.
Court does call the case of the people versus Gregory Martindale.
Overwater Assistant Prosecuting Attorney for the people.
Brian Bowling, Assistant Public Defender on behalf of Mr. Martindale. Gregory, state your name for the record, please.
Gregory Martindale.
Judge, we're asking for this matter to be set for an exam. I believe discovery to be complete.
People had their witnesses available the 18th.
My knowledge.
Preliminary examination in person will be set November 18th, 2025, 9 a.m. That is before Judge Washington.
Thank you, Your Honor.
All right, thank you. Bond continued. Thank you, sir. Court calls case of the people versus Mark Montgomery.
Ron Brown appearing on behalf of Mr. Montgomery, Your Honor.
Yes, sir. Mark Montgomery. Thank you, sir.
Your Honor, I have a green sheet. Request an adjournment.
Purpose.
Continued plea negotiations.
During this matter, November 25th, 2025, 9 a.m. Bond continued.
Thank you.
Hold on, you said what day?
The 25th. It's a Tuesday, sir.
Okay.
Thank you.
Yeah.
Court calls case people versus Jessica Williams.
Special call, I'm sorry, Mr. Cole. Jessica Williams.
Jess Williams. Did I start speaking French?
I think he's getting.
Court calls the case, People State of Michigan versus Jessica Williams.
Good afternoon, Your Honor. Bring for the people. Good afternoon, Your Honor. Justin Zayed, P1051 on behalf of Ms. Williams, present standing to my right. Ms. Williams, can you say your full name?
Jessica Camille Williams.
Thank you.
Your Honor, date and time set for the first PCC. We are respectfully requesting an adjournment to review discovery and for further negotiations. I've apprised my client of her rights with respect to waiving the 21-day rule. She's prepared to waive that.
Is that correct, ma'am?
Yes.
Probable cause, how much time did you need?
3 weeks, Your Honor. Pursuant to the.
I got the 26th or I have the 4th. Which would you prefer?
Would you prefer? Fourth, Your Honor, please.
That objection, probable cause conference will be adjourned December 4th, 2025, 9 a.m. Bond continued.
Thank you very much.
Thank you.
Your Honor.
Court calls case of the people versus Alexis Naveen.
Cash calls for the people.
Alexis Pluma, Assistant Public Defender, appearing on behalf of Ms. Naveen, who I believe is on Zoom. Ms. Naveen, could you unmute and say your full name?
Alexis Alexander Naveen.
Hello, Mr. Naveen.
Hello, Your Honor.
I
How
have
are
a
you?
plea. I'm good. How are you doing?
I'm very well. Thank you, Your Honor.
Good. I have a plea form. Is that what we're doing?
Yes, Your Honor.
All right. Plea form indicates that the defendant would be pleading no contest to 3 counts of attempted resisting, obstructing, and assaulting a police officer, the 1-year offenses. Upon her successful pleas to those charges, counts 1, 2, and 3 would be dismissed. The ones she's pleading to are counts 4, 5, and 6, if I didn't say so. The other agreement, there's a sentence agreement that the case would be transferred to the Veterans Treatment Court.
Yes. That is correct, Your Honor.
That's the court's full understanding. Is that correct, Ms.?
Yes, Your Honor.
Mr. Veen, if you could please raise your right hand, please. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you?
Yes, Your Honor.
All right. State your name again for the record, please.
Alexis Alexander Naveen.
All right. You can put your hand down. All right. So, Naveen, it's this court's understanding that you're going to be pleading no contest to 3 charges of attempted resisting and obstructing a police officer. Those are misdemeanors punishable by up to 1 year incarceration and $1,000 fine plus court costs. Do you understand that?
Yes, Your Honor.
Do you understand what a no contest plea is?
Yes, Your Honor.
All right, two things about it. I have to make sure that you understand it. First of all, it means that you're not further desirous or wanting to contest these charges. You understand that?
Yes, Your Honor.
Second thing is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
You understand also that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced initially before Judge Valvo in the 15th District Court.
Yes, Your Honor.
All right. Basis for the no contest plea.
Lack of recollection, Your Honor.
All right. Still wish to plead no contest?
Yes, Your Honor.
All right. To the charge of attempted resisting and obstructing a police officer as contained in count 4, how do you plead?
No contest, Your Honor.
To that same charge as contained in count 5, how do you plead?
No contest, Your Honor.
To that same charge as contained in count 6, how do you plead?
No contest, Your Honor.
You understand that by pleading no contest, you will not have a trial of any kind.
Correct.
You signed an advice of rights form or had it signed on your behalf. Is that correct?
Yes, Your Honor.
Any questions regarding any of those rights?
No, Your Honor.
You understand that you're giving up all those rights, including your trial rights contained in paragraph 5 on that form.
Absolutely.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
All right. Are you on probation or parole?
I am on probation, Your Honor.
All right. You were not on probation at the time of this offense. Is that correct?
Correct.
All right. Has anybody, can you please mute Doris Williams? Has anybody promised you anything other than what's been stated here today to get you to plead to these charges?
No, Your Honor.
Has anybody threatened you or coerced you in any way?
No, Your Honor.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
Court has been provided and has reviewed Ann Arbor Police Department report for their case number 2423393.
Your Honor, if I may interrupt just for a moment, you said,
Yes,
has
ma'am.
anybody promised me anything? I'm just going to say that the Father has promised me that it will be okay. So I have to speak the truth.
Understood. All
Yes,
right.
sir.
All right. The court has received and has reviewed Ann Arbor Police Department report for their case number 2423393. Any objections to the court reviewing that report?
No, Your Honor.
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of these offenses. Ms. Levine, I do have to advise you that if between the time that I accept your plea and the time of sentencing, that if you were to commit misconduct as defined under the Michigan court rules, that the court would no longer be bound by any sentence recommendation or evaluation, and you would not be entitled to withdraw your plea. You understand all of that, ma'am?
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
And have I complied with the court?
People are satisfied.
Defense is satisfied.
Court will accept the defendant's pleas of no contest to counts 4, 5, and 6. Counts 1, 2, and 3 are dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
December 2nd at 9 a.m.
December 2nd, 2025, 9 a.m. before Judge Valvo. Bond in this case will continue. I think, Ms. Naveen, that's finally come to a long road, right?
Yes, Your Honor. Yes, Your Honor. Can I just say thank you, definitely to yourself for your mercy. It's been a rough road. So thank you for your kindness to me. Thank you to the prosecutors. Especially thank you to my lawyers, Alex Warren Green, Lauren Perrine, and Hannah Apple, and the public defender in Veterans Court. I can't remember her name right now, Lamise. So I just wanted to say I'm incredibly grateful.
Mr. Mean, I have to say this. I don't say this to many defendants. I am going to miss you. We've been going through this whole process, and it has been tough. And the hard part for me was I can remember the first time seeing you and meeting you, and then just watching things kind of, I'll just say, spiral.
Yes, sir.
But then you finding the fortitude, and you're right along with all of the people that have been involved in this, to kind of bring yourself back, get well.
Yes, sir.
And then there were times that you would appear on Zoom, and I could tell that day was a struggle, but you got here, you went through it. And then one of the great joys was then seeing you the next time, because you could just tell by either the smile or whatever that you were doing much better, and just to watch you progress. So I guess from my standpoint, thank you for teaching me a little bit about life, and I guess the whole thing of not giving up, right?
Yes, sir.
And you are absolutely correct in terms of all the attorneys, including the prosecutors in this case, and everybody taking an interest, of thanking them for what they've done. Every public defender that appeared on this case, and certainly Ms. Feltes and the other prosecutors, were all interested in trying to make sure that this was a success for you.
Yes, Your Honor.
All right. Yes. And I'll say on behalf of all of them and myself that while you thank us, we are all mindful of the fact that your service to this country, what you did and everything, we have to thank you, because we get to do what we get to do because of people like you. And we're always mindful of that. All right.
It's my honor. Yes, sir. If I may, just one more, there is a social worker. I cannot remember his name. He did the mitigation. He did a great job also. I just want to make sure I thank everyone.
All right.
On the
well,
record.
Sometimes when you do that, you'll leave somebody out, but I think everybody gets the point. It's all right. Okay.
Yes, Your Honor.
Ms. Levine, take care of yourself. God bless you. Wish you all of the best. And certainly with Judge Valvo over there in the Veterans Court, and whoever then takes over after her in that court, you're in good hands.
Yes, sir. And God has blessed me, and through you.
All right. Thank you.
Your Honor.
You take care.
All right. God bless.
Thank you.
You know something? I'm just going to say this because I'm all Washtenaw County, all in. It is, for me, having sat here this long, one of the most fantastic things to hear a defendant not talk about one side or the other, not talk about one side or the other in a negative way, but talk about what cooperation there could be, and thank both the prosecution and defense and the court for how they proceeded in the case. I think everybody here in Washtenaw County, although even if you weren't involved, needs to be proud of that, because that's Washtenaw County, folks. Court does call the case of the people of the state of Michigan versus Aaron O'Rourke.
This is Public Defender Jay Bellinger on behalf of Mr. O'Rourke. Mr. O'Rourke, can you please state your name for the record?
Aaron O'Rourke.
And Your Honor, at this time, we were just seeking.
Everybody except Aaron. Go ahead. I had to do that. I tried to be nice.
I knew I didn't want to be.
I can only go so far.
I knew I didn't want to go right after that case. I knew it. I knew it. Your Honor, we are just seeking to set this matter for preliminary examination at this time. My understanding is that discovery is complete, at least to the best of my knowledge.
All right. And would the people have their witnesses available on the 18th? All right. Preliminary examination in person will be set November 18th, 2025, 9 a.m. That's before Judge Moore.
Yep.
Bond will continue.
Thank you very much.
Thank you.
Have a good rest of your day, Your Honor.
You're done?
I'm done.
All right, take
You're
care. Court calls the case, People versus Andrew Patton.
Government vote for the people.
Madam Judge, on behalf of Mr. Patton, who is approaching.
Your name, sir?
Andrew Spencer Patton.
All right, what are we doing?
Your Honor, we are asking for an adjournment. I did not have Mr. Patton's phone number. His phone had gotten stolen. I did get his advocate's phone number. They're working on getting him a new phone. We'd ask for an adjournment.
Advocate through what?
At Leaf.
Pardon?
Leaf Harm Reduction. Who is here in court with him.
Have you seen the violation report?
I have seen the violation report and we can address it.
Yes.
Yes, okay. Mr. Patton is unhoused, Your Honor. He did not intend not to test. He simply cannot afford it. He did get in contact with Community Corrections today. I believe he spoke to Maya, who's his corrections officer. She advised him, as did I, to continue to be in contact with Community Corrections, even if he can't pay for it, because it's better than just not talking to them at all. Now that he has his advocate helping him, we have his advocate's phone number, I believe.
Well, when was, go ahead,
Yeah.
counsel. Mr. Allen.
Your Honor, we'd ask for an adjournment and for him for his bond not to be denied. It's a simple matter of not being able to afford the testing. He's told me that he's not using, he is doing an incredible amount of community service at this Leaf Harm Reduction. His advocate and him are working really hard on, getting him all the help he needs to get housing, to get his phone. He does have that support system, which I think is very important to get him moving forward.
How long has he been working with the LEAF program?
Good.
For a couple months, sir. It's been hard being home.
Well, then I don't know. I mean, the reality of what I have sitting in front of me is that in the end of September, he tests positive for THC and cocaine.
Yes, sir.
And then I don't have another test. He's missed 6 consecutive tests. And if you're trying to tell me, counsel, that the advocates are going to help him, and that may be the case, where were they at any given point during the last 6 test periods?
I mean, they sometimes lose contact with him because whenever, they get him a phone, his last phone that they got him was stolen because he needed the phone for the tether. For one of his tethers. His phone was stolen.
I got that already.
Get the copy, badge numbers.
Go ahead.
Yes. His phone was stolen. He lost contact with them. He was able to get back in contact with them. He's been volunteering there. It's hard, Your Honor, being on the streets, being able to,
I get that, but the problem that I have is, had the testing been sporadic or had he been in touch with, then I can get that. But this is just.
May I speak on?
Go ahead.
I have no source of income. Or no source to getting up there to pay for the test. And even if I pay for the test, I have no way of getting up there. It's catch-22. So if I pay for the test, I still, I can't afford the test. So if I can't afford the test, I'm still violating because I can't pay for it.
How'd you get the first test?
I had scrounged up some money panhandling, and that against the law too. You asked me a question.
Yeah.
Is there anything from the people?
Your Honor, I'll add to the court's consideration that it was my intent to offer a reduction to use this. If this case involves a very small amount of controlled substance cocaine, and that is what he tested positive for. Bond was appropriate in this case, and unfortunately we rely on the bond conditions and the defendant's compliance with them for his safety and that of the community, and we'll defer to the court.
Anything else you want to say?
Nothing further, Your Honor.
I grant you the adjournment out 1 week to the 13th, 2025 at 9 AM, but this is not an adequate. I get poverty, I get all of that. But the thing is that when I have folks that can't afford to do it, they're at least in contact with community corrections. They're at least doing something, and I don't see any of that here. I see nothing. I see what really happened is he takes that first test as positive for 2 prohibited drugs and then doesn't show up.
You will be in contact with community corrections?
Yes, I've been talking to communications right after I left here this morning.
Well, yeah, once you realize you're in trouble, but what happened the past 6 weeks? I'm pretty much done. Bonds are revoked. We'll see him next week. Court calls the case, People versus Ramon Raymond.
Assistant Public Defender Sandra Light on behalf of Ramon Raymond. Your Honor, may
Take your hands out of your pockets.
I approach?
Yes. You're just seeking an adjournment.
Yes, Your Honor.
Is that right? Probable cause conference in this case will be adjourned November 25th, 2025, 9 AM, bond continue. All right, thank you, sir.
Thank you, Your Honor.
Court calls case People versus Bridget Murray.
Order assistant prosecuting attorney.
Assistant Public Defender, Your Honor, on behalf of Murray, who is approaching. Ms. Murray, state your name for the record, please.
Bridget Murray.
I have before me a plea form. Is that what we're doing?
That's correct, Your
The
Honor.
plea form indicates that the defendant will be pleading guilty to count 2 larceny less than $200, the 93-day offense. Upon a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the. Is that correct, Ms.
Yes, Your Honor. Yes, Your Honor. Yes, Your Honor. I apologize.
Ma'am, if you could please raise your right hand.
I'm sorry.
What do you?
Me or her?